think we should, just to keep things moving efficiently here, I think we should focus right now on the discussion the chair has raised about Attorney Wyckoff's objection about whether any testimony pertaining to violation 3 should be allowed. And so unless I misunderstood you, I don't think that comment was directly relevant to that point.
So if I'm not hearing from Greg or Fred, let's go ahead and.
Okay, and I am mindful of time, and I'm going to try to move it along. But I did want to address that issue around hearsay, as I think all parties have agreed that the rules of evidence do not apply here. And in any event, I'm actually basing this on not Mr. Morse's prior understanding of the property. I'm looking at the code enforcement officer's own photographs. And so I'm directing attention here to Exhibit B that shows some before and after photos. So I do see, I'm looking at the before, and it appears that there is a second set of staircase, and I'm just going to ask Mr. Morse about that.
I'm sorry, Leah, what would specifically just
Sure.
my understanding
so I'm directing your attention to, is it your understanding that these stairs pre-existed Mr. Buto's purchase of the property?
Yes,
okay.
That's my understanding.
And even though he didn't install them, is he insisting on keeping them?
No.
Did he have to remove them?
He would like to remove them. He is anxious to remove them, but so far has not been allowed to by the town of Raymond code enforcement and the DEP.
And is the removal part of your after the fact permit?
It's part of the restoration plan.
Okay. All right, moving on. Number 4 is a violation that talks about a jetty, that rock and sand below normal high mark has been added or altered. Would you speak to the issue of the jetty? You're familiar with this jetty? You've been on site?
Yes. Yeah.
Speak to that, if you would, please. And as you do, I'm going to go to some before and after photos, if you wouldn't mind talking about your understanding of the jetty.
Sure, I'd be happy to. There was a aerial photo evidence supports that there had been the DEP's aerial photo evidence, drone photos, the town's same evidence supports that there had been a stone jetty at this location.
And is this the photographic evidence you're referring to?
This is one of the photos, sure. Yeah. And a stone jetty is a structure for shoreline zoning purposes. If somebody wanted to construct a jetty today, stone jetty, they would have needed to have gone through this same piers, docks, and wharfs structures extending over or below the normal high water line, permanent structure permitting through the planning board. In this case, it's been there. The best we can tell, it predates any local ordinance or DEP regulation, as is the case with numerous similar jetties on the shoreline of Sebago Lake, and particularly this stretch of shoreline for that matter. Part of the project included repair and maintenance to the jetty. Some of the stone on the jetty had become dislodged either through wave action or ice action or a combination thereof. And like any other structure, your house, a shed, a garage, a retaining wall, a stone jetty, riprap, at some point, structures need to be repaired and maintained. That's the activity that occurred here.
And how was this repaired? Was new material added?
No, the material that the maintenance activity, repair and maintenance, was to pick up the stone that had become dislodged and was cast aside immediately adjacent to the stone jetty.
I will say, if I can ask you though, look at this, the before photo, that 9/20/21, and now I'm looking at this after photo. It sure does look a little bit bigger. Can you address why?
Well, sure. I mean, it sticks out of the water in the after photo a lot more, not because it's necessarily 2 stories higher than it had been. It sticks out of the water in large part because of the fact that the water level had dropped. In the before photo, the water level was much higher. So obviously not as much of the structure was exposed. So it's a more a water level issue than anything.
Understood. Okay, so turning to violation number 5, if we could. This is the allegation that the shoreline has been enlarged and expanded without a permit from the planning board. Is that something that we're going to stipulate to, in your view?
The enlarged and expanded shoreline is kind of an interesting twist, but the citation down below that, under right immediately beneath that, indicating that a permit from the planning board was required under section 14, table of land uses number 17B, I would absolutely agree with.
Right, but this is what the shoreline stabilization permit should have been under, this provision here. Okay.
That's absolutely correct.
Okay. So violation number 6, construction of a beach without a permit. I would like you to speak to that. Again, you've been to the property, you have a working familiarity of that property, correct?
Yes.
Okay, please speak to that allegation. In particular, was any sand brought in to create a beach, as far as you know?
No, there's been no fill brought in. There's been no formal beach created with the project. This allegation is, from my professional standpoint, it's unclear.
And as far as the term beach, are you aware whether that's defined in the ordinance?
I'm aware that it is not.
And what is your understanding when it is not? A term is not defined. What happens there?
The legal folks generally would indicate that at that point you defer to a standard dictionary definition or something.
And I put it to you that the standarddictionary.com definition is an expanse of sand or pebbles along the shore. Looking at the, I'm going to go to Exhibit C, which purports to be this newly created beach. Does that look to you like a traditionally, customarily defined beach?
No, that's stone riprap for shoreline stabilization.
Okay. So moving on, trying to be quick here. Violation 7 talks about removal of vegetation of at least 3 feet in height. And it cites section 15Q. That is clearing and removal of vegetation. Is that what is relevant here? Is that the proper section that would need to have a permit under?
Well, again, the vegetation that was less than 3 feet in height and other ground cover was removed in order to conduct the shoreline stabilization project. It was at the shoreline. There was very sparse vegetation on the slope face itself, the eroding slope in pockets, and that was removed for the shoreline project.
And Mr. Morse, the violation cites 15Q, but I'm directing your attention to 15C12. Again, 15C is this provision about uses below the high water body, right? High water mark. And it specifically states here, vegetation may be removed in excess of the standards of section 15Q, which is what was cited in violation 7, in order to conduct shoreline stabilization. And is that, I submit to you, is that what you're saying, is that that permit would encompass the removal of vegetation less than 3 feet in height?
Correct.
Thank you. And when revegetating under this provision, are you encumbered by section 15Q that was cited, or another section under the ordinance?
Right, it'd be section 15T, the revegetation standards.
And is the client going to be revegetating and consistent with those standards?
Yes.
Okay. Another allegation is that there's removal of brush in that stabilization zone. I'm going to show you back to, actually, I'm going to skip that. That's fine. We'll move on to violation number 8. Again, says the same thing, removal of vegetation of less than 3 feet in height without a permit. Cites to section 14.5. Is that the right provision?
It should be section 15C 12, I think it is the standard. Or in the land use table, I think it's 17B.
Right, and that allows basically removal of vegetation for shoreline project, correct?
Correct. Yes.
Okay. All right. So let's go to violation number 9, and that is alleges that a hot tub was built without a permit contrary to section 16B. Just bear with me one second. Can you talk to me about whether or not that hot tub, as you understand it, was put there as alleged by Mr. Buteau?
The hot tub was constructed or installed, however you want to say it, prior to Mr. Buteau's purchase of the property or management controls purchase of the property.
And how do you know that?
Aerial photo evidence and the town's own notice of violation aerial photo evidence as well.
And when are you referring to this piece where it says 2016 before and after is in 2018, correct?
Correct. Yes.
Are you aware when Mr. Buteau purchased the property?
Yes, April 2019.
Mr. Buteau insisting on keeping this?
No.
Is he willing to take it out at ASAP?
Yes.
Why hasn't he? Why hasn't he not?
He's not been allowed to at least as of this moment, from the town, code enforcement, or the Maine DEP.
And tell me, the next violation is also a setback violation. You mentioned that you have worked for DEP or worked for them for decades. When you experienced a situation when there was a violation by a prior landowner and essentially the new one was holding the bag, what did you do? Did you immediately violate them?
No, I've never seen any notice of violation sent for a violation that somebody, a former owner, had created on a property. Generally speaking, the advice that DEP would have given the town of Raymond in this case, or any other town running into this sort of situation, is work with the landowner, the current landowner, and try to achieve compliance by fixing the violation, removing a hot tub, removing a second set of stairs that's illegal under the standards. But it would be an informal request, and in some cases the landowner had to be prompted a little bit more. But again, that's from an informal verbal standpoint, and I just am not aware of any such case that elevated to a current owner being cited for a violation created by a former owner.
Okay, thank you. So I'm just gonna keep moving along here. Violation number 11, unpermitted shoreline stabilization, no permit. I think this is the very provision we have cited. We need to stipulate to that, correct?
Yes.
But is that not the same violation, the exact same violation as number 5?
It is.
And can you tell me why that is in your view?
Because it's the same. It's the same structure. It's the same citation. Section 14, table of land uses number 17B is for permanent piers, docks, wharves, bridges, etc. Structures that extend below the normal high water line require a planning board approval. Which
is exactly the same thing as section as the section cited in 11, correct?
Yes.
Different section of the ordinance, but the exact same requirement for the exact same uses, correct?
Correct.
Okay. Turning to violation number 12, there's it alleges unpermitted shoreline stabilization, no barge, and it cites section 15C12 that construction must access the shoreline when feasible. Can you speak to your knowledge about whether or not it was feasible to use the barge, please?
Sure. Absolutely. So,
and let me just ask you, Mr. Morse, and the basis for your knowledge in this regard as well.
Sure. For the specific project here, and for similar types of projects on Sebago Lake or any other lake, when you have a managed water level, namely an impoundment with an outlet dam that's able to be managed, you generally like to do these projects as a landowner, as a contractor, and as a municipality and DEP, when the water level is down, typically in the fall, not always, but generally in the fall and winter. And that's so that equipment and materials are not actively operating within the water, within standing water. So that was the case here. The water had receded adequately, and the contractor, Big Lake Marine Construction, proceeded with the project. Well, a barge, in order to utilize a barge for such a project, you have to have sufficient water level or water depth to be able to operate it. And there just wasn't, because they opted for the environmentally friendlier, environmentally more sound approach by operating or conducting the project in the dry, so to speak. So there wasn't sufficient water depth to get a barge in for the majority of the project. They were able to utilize the barge on the Whitetail property that you may bring up later for some of the repair and maintenance to the existing riprap that was on that property. But it was, and they also used it for the repair and maintenance to the stone jetty on the Fernwood property that we talked about a little earlier.
So they used it when feasible, and
Yes.
when they didn't, it was not feasible in your opinion.
Correct.
Okay. So moving on to violation 13, alleges unpermitted tree removal within 100 feet. And it cites once again, section 15Q. In the interest of time, I'm trying to, I don't want to testify for you, but Mr. Chairman, if you give me a little leeway, I would ask the witnesses that 15Q is not the appropriate section. We've heard you testify before that it's actually 15C12, which allows the removal of vegetation. Is that correct? Is that still your testimony?
Correct.
Okay. So I am going to go down to Exhibit G, which is the code officer's photographs in support of his contention in this regard. And we can see that there are trees 1 through 5, and then through 16. And these are all the trees that may have been removed with respect to the Shoreline Stabilization Project, correct?
Correct.
And of those 16 trees, look how almost all of them are located within that Shoreline Stabilization Project area, correct?
Right. Yeah, I should have qualified my last answer. Most of the trees needed to be removed for the Shoreline Stabilization Project. Of the 16 trees in this citation here, it appears that 2 were not required to be removed for the stabilization project.
Can you identify which ones those are, please?
Sure. They're trees number 1 and 4.
Okay. And I think the code enforcement officer acknowledged in the violation notice that if they're hazard trees, that they can in fact be removed upon consultation, correct? No permits required, but consultation is?
Correct.
And in your view, are trees 1 and 4 hazard trees? And if you can give us the basis of your opinion in that regard, that would be helpful.
Sure. In both my view and the tree contractor, who's a licensed arborist, it was his opinion as well. My opinion is based on the training I've received over the years when I worked for the state Department of Environmental Protection on hazard tree identification. And in this case, it really was pretty obvious even prior to reading Aaron Goslin or Q-Team's report. It was pretty obvious.
Just to interrupt you, Mr. Morris, I'm looking at Exhibit 5 here. Is that the letter that you were referencing?
Yes.
Where he says that the trees that were removed were partially dead or undermined by way of action and perfectly reasonable to take them down. Okay, thank you. So based on this letter and your professional judgment, I'm sorry I interrupted you.
No, exactly right. And I think common sense would also acknowledge they are hazard trees as well, or they're clearly unhealthy and within felling distance of the structure.
Okay, so back to the violation number 14. This alleges vegetation removal in excess of what is allowed under the point system. Again, the reference there is to section 15Q. And is it fair to say that that is, in your view, not the right one? It should be 15C12 dealing with shoreline stabilization.
Correct. Other than the 2 hazard trees.
Correct.
numbers.
but for all the reasons that you just stated, that they should have been able to be removed as well, correct?
Correct, without a permit.
Okay, without a permit, correct. And similarly, violation 15 cites to, this also alleges removal of vegetation without a permit, cites to section 14.5 of the land use. Again, same reason, not the right one?
Correct,
Okay.
exactly, without being redundant.
All right, and so what I'm hearing you say is that many of these violations were in fact redundant, correct?
Yes,
And, okay, and then with respect to the order of correction, I'm going to bring you back to that notice of violation. Sorry. And it talks about how, if you recall, that all of those violations must be remedied within 30 days, correct?
yes.
Can you talk to us about, for example, wouldn't remediation include revegetation and planting new trees?
Yes,
Well, if we're talking about December 16th, 30 days from that would take us through mid-January, correct?
yes.
Are nurseries open during the Christmas and holiday season in winter generally?
They may be open selling Christmas trees and wreaths and, various flowers, but they generally either don't have tree and shrub stock in stock in inventory, or else they aren't selling them because they're all a nursery will generally add or provide some guarantee that of survivability.
And in fact, isn't there in the ordinance a 80% survivability rate?
Correct.
And if you plant trees in the dead of winter, would that meet the 80% survivability rate?
The viability of trees planted in the winter would go way down from planting them during the normal planting season. The other piece, Lee, is it's impossible. I shouldn't say impossible. With a right sized piece of equipment tearing up the shoreline, you probably could break through 1.5 feet of frost to be able to plant a tree. But is that really what the town wants? Is that really what DEP wants? Is that what the landowner and contractor want? It doesn't make any sense.
I hear you. Okay, and so I'm turning your attention to a supplementary notice of violation here that was I submit to you that is a follow-up on the one we were just looking at, and no more additional violations, but it does have various corrective actions. And I don't want to belabor this point because I know we're getting in late in time, but if you could view all of these various required corrective actions, and please indicate, just quickly go through them and tell us if in fact those have been met. I would appreciate that.
Sure. For violations number 1 and 2, obtaining an after the fact permit for the filling and earth moving, we've talked about that. Generally speaking, you shouldn't be required to submit an application for that if you're submitting an application for another project that by default results in that kind of removal. Regardless, we have submitted the planning board application, and also for redundancy, we did submit an application to the code enforcement officer for filling and earth moving.
Can instead of reading every single one, but just viewing
Sure.
every one, can you tell me if those things have been submitted?
Sure. Violation number 3, after the fact permit for a second set of stairs. We don't intend to permit the second set of stairs. We intend to remove them. But we are awaiting for permission from the code enforcement office and DEP. So neither an after the fact permit application has been submitted, nor has it been removed for that reason.
Okay, and with respect to violation number 4, fair to say that it is we don't deem it to be a violation, so we're not going to ask for a permit, correct?
Correct. So repair and maintenance.
With respect to the expansion of the shoreline, number 5, you've submitted that application, correct?
Correct.
With respect to violation number 6, beach, after the fact beach, because we do not believe it to be a violation, you have not submitted that, correct?
Correct.
For 7 and 8, removal of shrub and ground cover, you have in fact submitted, correct?
Yes.
hot tub, you're not submitting because we're trying to rip it out and we're just waiting for approval for that, correct?
Correct.
11 and 12, shorefront stabilization project. In fact, you have applied for that permit, yes?
Yes.
Same for number 13
Yes.
and 14 and 15.
Correct.
Okay.
Yes.
Okay. All right. So I understand it's getting late, and I will thank you for your testimony in this regard, Mr. Morris. What I'm basically just going to do very quickly is to summarize actually, I wonder if the chairman is going to ask other parties if they want to question Mr. Morris before I wrap up. And I understand that the code officer probably has his testimony as well.
I think that we will reserve some time specifically for a question from Mr. Morse, but we can do that later.
Okay, so I'm just asking for some procedural clarification because that's my presentation with respect to testimony. As I understood the procedure, that after I examine a witness, then it's the opportunity for the other side to ask questions. So I didn't want to.
Yep, no, that's a good point. And I'll fall back to our attorney Wagner. I may have missed that point. So.
Yeah, no, I think it's appropriate to allow for questions during each witness. That does make sense. And then at the end of the testimony, if the board just has additional questions to Attorney Rachel on the arguments, we can do that at the end, but it does make sense at this time for if the board has any questions to direct them towards Mr. Morse, and also allow an opportunity for the other parties to ask any questions of Mr. Morse.
Well, given that, I do have one question specifically as I look at this for violations number 11 and 12, obtaining an after-fact permit for the Shoreline Stabilization project. Isn't that what this was all done under, a Shoreline Stabilization project? So why is there a need to get another permit?
Well, the primary purpose for a project on the property was indeed to conduct the shoreline stabilization. And then that by default encompasses, that activity encompasses these other various provisions, the vegetation removal, the limited vegetation removal that occurred, and filling and earth moving, of course.
Well, it was on my understanding that this was a shoreline stabilization project. So was there no permit?
That there was no permit, correct?
Okay, thank you.
Sure.
And if I may be very clear, I want to be very clear that we concede that there was not a permit sought, and we stipulate to that. What we are saying is really just drilling it down to its essence is that the permit requirement is under section 15C, and all of the and what happens there is when you apply to the planning board for a shoreline stabilization project, that application and review process encompasses all of the other things that we have been dinged for, such as earth moving, filling, vegetation removal, tree removal, because it's a global process. And so, yes, we concede we should have gotten the permit from the planning board. We did not, but all of those other permits that are supposed to be gotten from the code enforcement officer are subsumed into this planning board stabilization process. And that's really it in a nutshell.
Got it. Thank you. Tom, Greg, Fred, any questions for Attorney Ratchin or Mr. Morse?
Yeah, I had a question about you mentioned that there was an issue with, somebody had to act in the moment of discovery that their soil had a different water content in it. Are you saying that the work done prior to that discovery would have been covered by the stabilization permit? Or are you saying the work both before and after that discovery would have been covered by a stabilization permit?
All of the work would have been covered under the town's review. Extending the height of the riprap above the water, normal high water line, to the extent that became necessary because of that soil condition, exceeded the simpler DEP permitting process, the permit by rule. So it exceeded that permit, but it would have been the same permit under the town planning board review. If I answered your question.
Okay, yeah.
Tom, Fred, any questions?
No, I don't have any right now.
No, I'll hold off.
So, Mr. Chairman, as far as bringing in evidence, that concludes my portion for this particular appeal. I would reserve some time for a summation after, I think, Mr. Wyckoff, I'm sure, is looking to put in his case now.
Yes, I believe that was our orders of procedure, so.
Mr. Chairman, may I had two questions for Mr. Morse.
Of course. Go right ahead.
Okay, I'm waiting for him to turn on his microphone. Mr. Morse, now, did you personally see this site before any of the work that is at issue was completed?
No.
Okay, and the basis for your testimony about its condition, that was based on a conversation you had with Mr. Durant, is that right?
Yes, including photographs provided by the town, the DEP, Mr. Durant prior to construction.
But your testimony about the condition of the property, and I think I heard you say that it was based on a conversation you had with Mr. Durant.
Well, if I limited it to that, that was in error. Again, to just repeat myself, it was based on the conversation with Mr. Durant on site and reviewing the photographs from the Portland Water District, DEP, Town of Raymond, and any other photographs that have been floating around prior to construction at this property.
You testified that this site, there was active erosion going on, and that testimony is based on a discussion you had with Mr. Durant.
That was one component. I mean, I hate to sound redundant, and I apologize for that. But yes, that was one component of it. And then as I, again, will mention the photographs from Portland Water District, the Town of Raymond, the DEP, and any other photographs, the contractor, Big Lake Marine Construction, and some of their before photographs as well.
I don't have any other questions. Thank you. I should say I don't have any more questions for Mr. Morse. So then, Mr. Chairman, do I understand that it's now you're looking to the town to make to respond or to present with regards to the notice of violation of December 16th to management controls?
Yeah, please.
Okay.
Given our board has no more questions at the moment
Very good.
for the appellant. Yep.
I'd like to ask Attorney Rachel to stop sharing her screen, please.
Oh, sure, I'm sorry.
So, Mr. Chairman, the thought here and how we would approach this is that first I'm going to ask Alex Soroy is the code enforcement officer, to provide a general description of the violations relating to 18 Fernwood. And then after that, then he and I would jointly address the issues raised by the applicants in their administrative appeals, if that's acceptable to the chairman.
That is acceptable. Please
Okay.
proceed.
Hey, David, this is Tom. Could I ask for a 1-minute stretch break?
That I believe that is reasonable, but I'll make sure from Attorney Wagner that we're not doing anything
Yeah,
wrong.
yeah, nope, that's very reasonable.
Yeah, that's how you do it with the judge at the yeah.
So Attorney Wyckoff, it looks like we're simply waiting on Alex.
That's right.
Oh, no, I'm here. I'm ready.
Very good.
Okay. Are we ready to begin again?
Yes, please.
Okay. I'd like to just turn it over to Alex and ask him to provide a general description of the violations with regards to 18 Fernwood Road, please.
All right. Well, good evening, everyone. For some reason, my computer, if I get too far away, it cuts out. So if I start to cut out, just yell at me. And I'm going to try and go through this. All right. Can you guys see everything or see my presentation? Good. So I'll go through this as quickly as I can because I know a lot of this information is repeat at this point. But like we had mentioned, this all came about in October when a member of DEP alerted us of a violation on Sebago Lake. She was out enjoying a vacation day, and she happened to stumble across this particular property. So she sent us an email or copied us on an email to Rob Durant and included some photos that we then followed up on. Following that email, we did some initial investigation into the property and found that no permits had been approved or submitted for the activity that was taking place on the water. So we went out and did an inspection, with DEP, Portland Water District, and Rob Durant and Heidi. And, we were able to walk the site, walk both properties. These photos will be specific to 18 Fernwood, but we initially saw a substantial amount of riprap had been placed on site, some soil disturbance, a good amount of soil disturbance within 100 feet of the water. This standing there, the photo doesn't really do it justice, but standing there, this wall is, a good 8 to 10 feet, probably in spots. So it is pretty, it's pretty incredible to see in person. Definitely one of the largest waterfront violations that I have ever experienced in the almost 10 years that I've been doing this. So we were very surprised to see this. Rob Durant's a contractor that has done a lot of work on the lakes. So it was kind of disappointing to see. So here's another photo of the house. So I'll just kind of briefly go through some of the violations that we've cited on our NOVs. We included filling and earth moving of more than 10 cubic yards without a permit. There is a significant amount of material that was disturbed and brought in to the site. All of this riprap and all of the buffer between the house and the garage and the water was disturbed in some sense. So practically all the vegetation in this area was stripped, graded, removed. Here you can see the excavator actually in the woods, and it looks as though they've got a grader down there as well, regrading that portion of the lot. And it's also important to note that while there is erosion control on site, there was no approved erosion control plan, which is a requirement for a project like this. And also you can see that the erosion control in the lower left-hand corner doesn't really appear to be doing anything other than flapping in the wind. It doesn't look as though it's correctly towed in. It's actually fallen over. And I'm not even really sure what purpose it was there for, other than to appear as though, from the water, erosion control is up. Doesn't look like it's doing much. So the next one would be the illegal shoreline access. There is a second set of stairs. Now, I would like to also note that these drone photos, these fantastic drone photos, were provided to the town from Portland Water District. This was actually a project. They had a drone fly the entire lake in September. So this photo, it could have been taken days before this project started. It does show that there is what appears to be a permanent set of stairs to access the water, and then there's also a second movable aluminum section of stairs that was also used to access what I believe was a dock at one point, maybe. They had basically made that second set of stairs permanent through this project, as you can see here. The next one we have is for the jetty, the work for the jetty. And that is, this area here, which Leah had talked about for a little bit. it has some vegetation on it. It's made up of, a good section of rock. I don't know, it's probably 75, 50 feet long or so. But what we did find down there was it's very clear that rocks have been added to the jetty, and this non-conforming jetty, if you want to call it, has been pretty substantially expanded. And Mike did mention that the water levels were lower when this project was done. That may be the case, but I would draw your attention to the bottom of the stairs on the left-hand side, and you can kind of see where the water line is when this photo was taken, and the bottom of the stairs on this photo. It is probably a little bit lower. But one of the things you can notice at the end of the jetty, horizontally, it's pretty level. And in the original photo, when the water was lower, it's much higher on the side closer to the shoreline. So it does appear as though rocks were added on the lower end, further out into the water. And this is obviously something that would have required a permit from DEP and the planning board, and obviously none of those permits were obtained. So moving along, you can see here significant scarring on the rocks. Obviously, these rocks have been moved around quite a bit in the project. The next one would actually be the shoreline work itself. I don't know what everyone's level of understanding is of the natural environment with a lake, but the reason the state has set these standards is to protect water quality, obviously. And that 100-foot buffer is buffering stormwater. It's buffering all the water that's coming towards the lake. It's catching rainwater, but it's also environment for all sorts of different wildlife species, fish, frogs, turtles. And this is a natural environment, an ecosystem for all these species. And that's a big part of what DEP wants to protect as well. So this is an ideal shorefront. Yeah, there may be some wave action erosion. It looks like there was a tree that was cut at one point. And those stumps look like they're actually holding that shoreline together pretty well. You see a lot of vegetation. Looks pretty healthy. What they did is they basically took all of that out. Now you've got a ramp into the water that's heating up surface water or rainwater as it goes down into the lake. You have no shade for frogs, turtles, minnows, fish, anything that's in there. It's direct sunlight, heating those rocks up and heating the water up, which, as we all know, is going to negatively affect the water quality. So this is something that DEP tries to avoid because it's really negatively impacting the environment. So construction of a beach. I know this one is one that probably can be debated quite a bit, but the shorefront is very rocky here. There's a lot of rock, and if you look into the water, it's all rock. There's practically no sand showing here. This particular section right here. And if you look in this photo, it looks as though a lot of the rocks have been removed. Now, those steps were going down to this now sand area, which is likely going to create an ideal environment for a beach area for them to set up chairs when the water is lower, or hang out in a flat spot near the water. So they may not have brought sand in, but it looks as though all of the larger rocks had been removed to actually create that beach. So I do feel as though that is beach construction, and construction doesn't necessarily mean bringing in sand. It can be removal of rock to create that beach area. Removal of vegetation less than 3 feet in height without a permit. I just want to touch on real quick redundancy. That seems to be the thing that I keep hearing, redundancy in the NOV. There are multiple different ways someone can violate a section of the ordinance, in my opinion. To remove a tree without a permit that requires a permit is a violation of the ordinance. To remove a number of trees that exceed the allowed amount of trees you can remove legally is also a violation. So you can have a violation of a standard and a violation of the requirement to get a permit. So I can understand it may seem redundant, but it's really, in my opinion, is two separate violations. You can get a permit to remove trees and then exceed what's allowed for removal. But in this case, they just didn't get a permit, and they also removed the trees. So Again, going back to this photo, there's shorefront that includes plenty of trees less than 3 feet in height, which can't be removed within 100 feet. They're there for a reason, to protect that 100-foot buffer. All of these trees have been removed. Now, I know there's standards that allow for vegetation removal for a shoreline stabilization project, but that is only when that's permitted, and that goes through the planning board. You can't just remove all the vegetation to do the shoreline stabilization and then say, oh yeah, we'll get the permit after. Oh, by the way, the trees have already been removed, so you're going to have to allow us to remove them. You're supposed to get that approval up front because the planning board has the ability to review that and possibly say no. So I think that's an important part of this. Yes, vegetation removal is allowed associated with that project if it's a legal project, of course. So again, on the other side, there's the wooded area. If you want to direct your attention there, where the red box is, there was ferns, some ground cover, natural packed pine needles, all sorts of ground cover in there. That was all removed. Obviously, you cannot remove that with a permit unless it's for an allowed use. And you obviously need a permit to do it. So I feel like that's two violations, two separate violations. Structure built without a permit in violation of the required setbacks. Again, another redundancy, that's two separate violations. The structure is too close to the water, violation number one. Violation number two, it was done without a permit. Yes, it may not have been done by the current owner, but unfortunately, it's really up to a property owner to do their due diligence when they purchase a property to make sure they're not buying a violation. It's a very common thing that happens. It's something that happens every day. Someone will buy a property with a violation. Unfortunately, you buy a violation, regardless of who did the violation. You're the current property owner, and you have to take care of that. Now, one of the things I've heard a couple of times tonight is the town hasn't allowed them to remove this hot tub. I did actually have a welcome conversation with Rob Durant, I believe it was last week, and he requested the ability to be able to remove the hot tub immediately. And the town has no objection with them removing the hot tub, but what I asked he do is basically apply for a demo permit to remove that hot tub. We just want to make sure that however they're removing it in a safe, practical manner. We want to make sure there's erosion control up because there'll be some soil disturbance. And we also want to make sure that area is revegetated. I have not received a permit to remove the hot tub, I believe. We did receive some permit applications for the after the fact tree removal and stuff like that, but I don't believe we've seen one specific for demo removal of the hot tub. So I wouldn't say that the town is not allowing them to remove this hot tub. I definitely think that's a dramatic exaggeration of the current situation, for sure. So there's a picture of the hot tub. The work done on land versus barge. This area is accessible by barge. It's definitely something that Rob Durant's able to do. He has access to the barge. And I think the goal would be to see as much of that work done from the water as possible to avoid, any unnecessary soil disturbance. The water levels in October are typically low, but there's no reason that the work necessarily needs to be done in October, I suppose. So it really is something that we would prefer to see as little soil disturbance as possible. So we're getting towards the end of this year. Unpermitted tree removal within 100 feet of Sebago Lake. Q team did agree that they completed the tree removal portion of the project. I counted here, I believe 5 trees that have been cut. They're claiming these are hazards. That requires a consultation from the code officer to make that determination. Unfortunately, they've been removed. We don't know that they were hazards. So now we really can't treat them as hazards because they don't exist anymore. I know they are claiming, in their professional opinion, that they are hazard trees. However, they also profited from the removal of these hazard trees. So I do find it a little concerning that a company that profited from the removal of these trees is claiming they're hazards without any consult to the code officer. they can claim 50 trees are hazards without consult of the code officer, and then, you know, profit greatly from those 50 trees and then claim after the fact that they were hazards. So that's just an example, but I feel like that is kind of questionable and a slippery slope to go down for sure. So we got the 5 there, and then, you know, quite a few more on this side. Now, for example, I know 14, the claim was that the tree is a hazard and needed to be removed. I'm not exactly sure what the hazard is. It looks healthy, it's leaning. I don't know what the danger of it falling on is, but if you look at 13 and 12, these look to be healthy, straight. I don't see any erosion underneath them. The root system looks to be intact. So I'm not exactly sure what the need is, other than, you know, the bank was eroding. You know, roots help hold the bank together. And if you're going to riprap and pull out all of the root system 10 or 12 feet up onto the shore, you've totally destroyed the integrity of that bank. You're going to have more erosion, and it's going to get soft, and you'll need to carry the riprap up further because you've totally pulled everything out. I think if you leave the root system in place, it's not going to be as pretty, maybe to someone, but you know, it might not require 8 feet of riprap. You know, you might be able to do it with 2 feet. So last couple of slides here. So they have created an opening by removing these trees that's larger than 250 square feet, which is a restriction. So obviously significant revegetation is going to be required. They've also removed, you know, trees in excess of what would be allowed by the point system. You can only remove, selectively, you can only remove so many trees within a 25 by 50 foot grid. And we won't get into the details there because it can get kind of confusing, but each tree diameter is given a point and you have to maintain so many points. So, you know, we have estimated that they've removed really all of the points that remained in 3 grids, which is not allowed. If you don't have the minimum 24 points, you actually can't remove any trees selectively, unless they are hazards, but you must first you know, consult with the code officer. So that's it. That's all I have for slides on this particular property. And I will segue back to Eric.
Thanks. I actually have a quick question for you. I just want to follow up on.
Yep.
You were talking about hazard trees for a moment there, and you said that with hazard trees, leaving the root systems in helps to stabilize the shore. Is that right?
Yeah. Yeah, actually, and they're required to. You know, within 100 feet, you can't remove the root system because for that very reason.
And that's actually recognized by the Shoreland zoning ordinance, isn't that right?
Yeah.
Okay. So I'm going to share my screen if I can. Are you able to see my presentation?
Yep.
Yes.
Okay, bear with me. Can you still see it?
Yes.
Okay, and you see me turning pages?
Not now.
No, no, we see your Word document now.
Okay, hang on here. Do you see it now?
Yep. Yeah, you got it now.
Okay, thank you very much. I'd also ask that the members of the board, if you could have the December 16th, 2021 notice of violation there, because as we go through, I'm going to ask Alex to discuss some of the exhibits to that. So if you could just keep that handy, I would appreciate that. I want to begin where Attorney Rachel began. She said that one thing that's important here is who's responsible. And what's important here is that as the property owner, management controls is responsible for what happens at its property and at its direction. And here it has hired contractors, Mr. Durant or Big Lake Marine Construction or Durant Excavating, you know, whoever the right person, the right name is, and then also Q Team to do work on his property, and they're his agent. He hired them to do the project. The management control hired them to do the project, and he acknowledged, and MCL acknowledges that it asked Mr. Durant to obtain the permits, and in connection with the Durant exhibiting his appeal, he submitted a permit by oral notification form to the DEP, and it identifies him as the agent for management controls. So as the property owner and as the principal for the agent, directing the agent, management controls is responsible for the actions of its contractors. And Maine statute recognized that under Title 30A, Section 4452, it says that an owner is liable for violations. And then Title 38, Section 444 says that any person who orders or conducts any activity in violation of a municipal ordinance adopted under this chapter is penalized. And here, we're not talking about penalties, but you have to necessarily be held responsible for the violations. And the ordinance itself, the Shoreline zoning ordinance, recognizes that too at Section 16C. It requires that permits be signed by an owner or someone authorized by the owner, and also does recognize that where someone that the violators include the owner. Okay, now the first appeal issue that the MCL's raised relates to violation number 1, and that relates to soil and water conservation practices, and they contend that's allowed in this zone without a permit, and complain that there is no explanation or evidence that the work wasn't conducted in a way to prevent erosion or sedimentation. So this first violation relates to filling and earth moving, and as Alex just testified a moment ago, there's significant filling and earth moving that occurred on this property, and he also testified that the work wasn't done in a way that prevented erosion and sedimentation because it had inadequate erosion and sedimentation control plans. And here, the filling and earth moving that occurred was more than 10 cubic yards, and as a result, a permit from the code enforcement officer was required for the work. And the ordinance provides that where that happens, and this is at Section 15U1, that the activity must be completed in a way to prevent erosion and sedimentation, and requires that the activity be done in accordance with an erosion and sedimentation control plan. And I guess I would just direct the question to Alex. Was an erosion and sedimentation control plan prepared or submitted?
No, not prior to the work being completed.
Okay. So as a result, the filling and earth moving that occurred was in violation of the ordinance because it wasn't done in a way to prevent erosion and sedimentation. Now, the next violation that they raised some issues with regards to is violation number 4, and this relates to the jetty. And they contend, well, this jetty was pre-existing, and the work that was done on it was repair and maintenance, and that could be done without a permit. Now, as a permanent structure, the jetty required planning board approval. Now, I'd ask Alex, does the town have any record of any planning board approval for the jetty? You're muted, Alex.
No, we don't.
Okay, and now the Shoreline zoning ordinance also requires that the jetty have a permit from the Department of Environmental Protection. Now, Alex, is the town aware of any permit from the Department of Environmental Protection?
I'm not aware of a permit from the Department of Environmental.
So as a result of that, the jetty is non-conforming. Now, as a non-conforming structure, the jetty can only be expanded, reconstructed, or replaced with a permit, and we know that by looking at the Shoreline zoning ordinance at Section 12C. Now, I'm not exactly sure, but I think that MCL would rely on a statutory provision for the proposition that a permit is not required, and that being 38 MRS 480-Q2. Now, however, when you look at that statute, it says by its terms that it doesn't apply where the town requires a permit for the activity, and that's the case here. Now, Alex, if I could have you just explain to the board by looking at Exhibit D to the notice of violation, you could just refer to that and describe the violation, please. You're muted there.
Yeah, so like I said before, I mean, you can clearly see that vegetation, was removed from this. And based on looking at the water heights, you can tell it is out of the water a little bit more, but the end that's further out into the water definitely appears to be level with the end that's closer to the shore. So it appears as though there's been some construction or modification, expansion to this jetty.
Okay, thank you. Okay, now we're going to violation 5, and violation 5 is that the shoreline has been enlarged or expanded without a permit from the planning board. Now, Alex, could you go to exhibit C to the notice of violation and use that and describe the violation to the board, please?
Yeah, I mean, a significant amount of filling has taken place here, and that shoreline naturally jogged in and out in spots, and now it's a straight line across. And if you look specifically next to the stairs where the large stump was on the before photo, that shoreline jogged in further than it does now. It actually is even across there.
Okay, now I'm jumping ahead a little bit, but earlier, Attorney Rachel, she stated that violation 11, which is an unpermitted shoreline stabilization, the violation because there wasn't a permit for the shoreline stabilization project. That's essentially the same thing as violation 5 with the shoreline being enlarged or expanded here. Can you just describe, Alex, the difference there?
Yeah, sorry, that was violation 11.
Yes.
So, that is that type of activity requires a permit from the planning board, and again, that's something that they have to approve of, along with the violation removal that comes along with that, and they didn't get that.
How is shoreland stabilization different from shoreline enlargement or expansion?
Yeah, so shoreline stabilization is usually necessary to correct an erosion issue and is limited to specifically the correction of that problem. Expansion of the shoreline is simply enlarging that shoreline or expanding down into below the normal high water mark.
So they really are different.
They are different, and that you don't necessarily need to expand the shoreline to correct an erosion control problem, and vice versa.
Okay. The next violation is violation 6, and management controls argues that exhibit C to the notice of violation doesn't show a beach being constructed, and it just shows large pieces of riprap. And they also say, well, the shoreline zoning ordinance doesn't define what a beach is, and they go to dictionary.com and they say a beach is an expanse of sand or pebbles along a shore, and exhibit C just doesn't show that. Now, we live in Maine, and I think people in Maine understand a beach can be made of stones and rocks. And when you go to merriam-webster.com, which is another dictionary online, it recognizes that. It says that a beach, among the definitions for beach are the shore of a body of water covered by sand, gravel, or larger rock fragments. And I think we all know a beach can be composed of stones and rocks. And, as Alex testified earlier, exhibit C to the notice of violation shows that the beach area is significantly larger than it was before. And the expansion of a beach necessarily requires construction and a permit from the Department of Environmental Protection. And under the ordinance, because that didn't happen, there's a violation. Okay. Violations 7 and 8. And so violation 7 is removal of vegetation less than 3 feet in height, and 8 is removal of vegetation less than 3 feet in height without a permit. And the contention in the appeal is the existing vegetation wasn't removed. It was just trimmed down, leaving root systems intact and topped out with mulch. Now, the shoreline zoning ordinance prohibits the clearing or removal of vegetation under 3 feet within 100 feet of the normal high water line, and the clearing or removal of vegetation of any height, not just 3 feet or less, of any height without a permit. So Alex, I'd like you to refer to Exhibit C to the notice of violation and just describe this violation, these two violations, please.
Yes, so Exhibit C shows all of the ground cover, the vegetation less than 3 feet in height. In that buffer zone, the 100-foot setback area has been removed. You know, and like you said, removed in this situation might actually be it was covered over, but you can't actually reduce the height of this vegetation. The whole point of it is to allow it to grow up. You can't be you know, vertically limiting and pruning that vegetation down. So covering over that is essentially doing that. They are limiting the height and they're stamping it out. I mean, they're killing it is what they're doing.
So let's assume for a moment that there was vegetation greater than 3 feet high within the normal high water, within 100 feet of the normal high water level. Let's assume it was higher than 3 feet and it was removed. Would that be a violation here, Alex?
Yeah, absolutely, because removal of you know, vegetation that doesn't meet the standards without a permit within 100 feet in general would be considered a violation, unless it's, you know, legally allowed through a permit.
Right. Now, under section 15C12 of the Shoreline zoning ordinance, it says that vegetation may be removed in excess of the standards in section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. So does that provision apply here, Alex?
No, it definitely, it wouldn't, because the planning board didn't issue a permit. So we can't do this on speculation that the planning board would have issued a permit. It just doesn't work that way. It doesn't make any sense to do that. So no, I wouldn't say that applies.
Thank you. Okay, the next violation is violation number 12, and violation 12 is for conducting the shoreline stabilization project without a barge. Now, in the appeal, MCL contends that determination must be made by the planning board and can't be made by the code enforcement officer in a violation. Now, that's just not true. Under section 16H2 of the Shoreline zoning ordinance, it says that the code enforcement officer, if the code enforcement officer finds any provision being violated, then he or she shall notify in writing the person responsible for the violation. So in other words, the ordinance gives the code enforcement officer the duty of enforcing the ordinance and the task of determining if any violations have occurred. So the ordinance doesn't give the planning board any role regarding violations. The task is given to the code enforcement officer, and it's the job of the code enforcement officer to make that determination. And here, Alex determined that using a barge would have been feasible. Can you just describe the basis for that, Alex?
Yeah, you're exactly right. I mean, the planning board doesn't have an enforcement role. That's really the code officer's job. And it is clear that, you know, this property could be accessed by the barge, maybe not all year. There might be certain times a year where it's easier, or certain segments of the shoreline where it's easier. But I think it's definitely possible to be accessed by barge.
Okay, before I get here, I just wanted to ask you a few general questions, Alex. Now, Mr. Morse testified that an eroding shoreline is a common issue on Sebago Lake. Would you agree that's a common issue?
You know, it is, but it's, you know, it's normally an issue that is very apparent in certain spots and very obvious in certain spots. But, you know, it's not something that is often corrected on a 400-foot long segment of shoreline.
That was going to be my follow-up question. Is this project a common way to deal with that issue and approach that issue?
I would say it's definitely one of a kind on Sebago Lake. So no, it's not a common path to correct the problem.
And in your view, and in your opinion, has this project caused environmental damage?
Oh yeah, absolutely.
And could you just give us an overview of the damage that you think has occurred as a result of it?
Yeah, absolutely. I mean, this rock, in the summer when the sun's on it all day long, is going to be heating up. That afternoon thunderstorm that comes through, the water running across the lawn down towards the lake is going to run over these rocks. It's going to get heated up by the already warm rocks and run into Sebago Lake, which will increase the water temps, which leads to all sorts of other water quality issues. And I already spoke on, the damage to the natural wildlife habitat, the ecosystem that existed on that shorefront, that's now been removed. So yeah, I would say that environmentally, there's definitely damage that's been done.
Mr. Morse testified that this project was net helpful. You agree?
No, I wouldn't agree.
Now, are there aspects of this stabilization project, in your view, that would not be permitted if an application had been submitted for it?
Absolutely. I think there's parts of this that exceed what would be allowed. I can't really answer specifics for what the planning board, for example, might allow or might not allow. But I do think there are a number of portions of this that just couldn't be allowed with an after-the-fact permit.
Okay, and can you give? There's some examples that you have in mind when you think.
Yeah, the vegetation removal less than 3 feet in height. You are allowed to remove vegetation less than 3 feet in height for example, a path to access the water, a 6-foot meandering path to access the water. Beyond that, they wouldn't have been allowed to remove all of that or do that soil disturbance, that regrading within that area. The hot tub wouldn't be allowed within 100 feet, for example. Removal of the larger trees, it's possible, it's likely that a number of those trees weren't hazard trees. So yeah, I would definitely say this isn't all possible through an after-the-fact permit.
Okay, so let's talk about the hazard trees for a moment. Let's assume the trees that were removed were hazard trees. What should have happened before they were removed?
They should have consulted with the code officer. Either myself or Chris would have gone down there to meet with them or to look at the marked trees that they wish to remove. And we would have made that determination then, or requested more information from a licensed professional to make that qualification as a hazard tree. Definitely would require replanting since they're exceeding, let's say theoretically we called them hazard trees and allowed them to be removed. They're exceeding that 250 square foot canopy opening, so replanting is 100% absolutely necessary.
Okay, now is it your understanding that the hazard trees that were removed, that the stumps were removed too?
Yes, it does appear as though by looking at the photos of the activity taking place, walking around the site, there were numerous spots in that area where trees were removed where the ground was very soft. And it appears as though these stumps were removed.
Okay, now, and does the Shoreline zoning ordinance recognize that stumps from hazard trees can be removed?
Yeah, and it's an unnecessary soil disturbance, and the goal is to help keep that root system in the ground, keeping the shorefront intact as much as possible.
And that's why the ordinance prohibits the removal of the stumps, right? Can you hear me?
Yep.
Okay. I just want, and that's why the ordinance prohibits the removal of stumps from hazard trees, right?
Yes.
Okay. Now, you learned of this project from the Department of Environmental Protection, right?
Yep.
Did anyone contact you regarding any issues with this project before the DEP did?
No.
Okay. Now, there are some procedural issues that MCL's raised with regards to the notices of violation, and these are essentially that there are a number of violations that are the same violation and that they're only listed twice by the town in order to seek duplicative fees. So first, I just want to say and address this. Fines aren't an issue for the Zoning Board of Appeals. That's separate from the violations. The task for the Zoning Board of Appeals is to determine whether or not there were violations. Fines aren't for the Zoning Board of Appeals to deal with, and the Zoning Board of Appeals doesn't have a role with assessing fines. So we need to put that to the side. Now, so first, violations 1 and 2. These are separate violations. Violation 1 is for filling and earth moving without steps being taken to prevent erosion and sedimentation. Violation 2 is for filling and earth moving without a permit. Those two violations are not dependent on one another. Even if there was a permit for filling and earth moving, there would still have been a violation for the failure to take steps to prevent erosion and sedimentation. And on the flip side, even if steps had been taken to prevent erosion and sedimentation, but there's no permit, that would still be a violation. So those two violations are separate and distinct, and they're not the same thing. Violation 7 and 8. Same thing, they are different. Violation 7 relates to violation of the requirement that vegetation less than 3 feet cannot be cut, covered, or removed except for footpath or other permitted uses under the ordinance. And violation 8 is for removing vegetation without a permit, and that's vegetation without regards to height. So those two violations are separate and distinct. They're just not the same thing. 11 and 12, same situation. 11 is for stabilizing the shorefront without a permit. 12 is for stabilizing the shorefront without a barge, when it could have been done with a barge. So let's assume that there had been a permit to stabilize the shorefront and the barge wasn't used. That would still generate a violation if it could be used. So those two violations are separate and distinct. They're not the same thing. The violations 14 and 15, same thing. Violation 14 is based on section 15Q2B, which allows for selective cutting of trees within a buffer strip, as long as there's a well-distributed stand of trees and other vegetation is maintained, and if other trees are present, which provide sufficient points to allow for selective cutting of those otherwise healthy trees. And as Alex described, that violation exists. Now, violation 15 is for removing vegetation without a permit. So even if vegetation in excess of selective cutting occurred with a permit, it would be a violation. And even if vegetation was cut not in excess of selective cutting, it would still be a violation because a permit was required. And then also the trees were removed from a 6,000 square foot area between the house and the normal high water level in what would have been 3 25 by 50 foot grids, which didn't contain enough points to support the selective removal. And as Alex described, that's the case. These violations are different. Now, MCL also raises in its appeal that there is an explanation of action needed to correct violations that needs to be in the notice of violation, and that in the notices of violation that the code enforcement officer provided insufficient explanation of the actions needed to correct the violations. So in the ordinance, section 16H2 provides that there needs to be it needs to provide for an order for the action needed to correct it, and that there needs to be an indication of that. Now, here the NOV states that all referenced violations must be corrected within 30 days of the date of this notice, and then the corrections must include, but not be limited to, the submission of a plan and to comply with the requirements of the statute, and that's sufficient. That's the same level of detail as contemplated by the ordinance, and there's no issue with that at all. And in any event, a supplemental notice of violation was provided that provides additional guidance, and no appeal has been taken from that supplemental notice of violation. And with that, I think that completes our presentation regarding the December 16th, 2021 notice of violation.
Good. So, Attorney Wagner, is it
Sure,
for us to ask questions, let Attorney Ratchin ask her questions first. What would you recommend?
If I recall, our procedure last time was the other attorney and then the board. Someone
Agreed.
correct me if I'm wrong. But,
No, you're right.
so then I would go with Attorney Ratchin first.
Great, thank you so much, and I'll be quick. So I just had a couple of questions for Alex. Is it Soroy? I want to make sure I pronounce your name correctly.
You can say it however you want, but I say Seroy's. So.
Seroy's, okay, you got it. All right, thank you. So some of these are just really technical, but did you determine when the work to proceed began, actually? Were you aware of when that happened?
I don't know of the specific date. I do believe we reached out to someone to get a date of when that work actually started. I don't believe we ever heard back. So the date that I have right now is October 14th, because that's the date that Alexis sent us the email.
Fair enough, thanks. Okay. I didn't mean to cut you off, I'm sorry.
No, it's fine.
Okay. Do you know how many days thereafter from the time it started that work continued after it began?
I have no clue. No, I'm not aware.
Okay. How about, did you actually issue a stop work order? Oh, I can't hear you. You're on mute.
Yeah, we did not. We issued a notice of violation December 16th, I believe.
So never actually told them to stop work?
We did. When we met with them on site, it was don't continue anything.
Okay. So basically it was a verbal stop work order.
Yeah.
And that was on, I think in your notice of violation, it was the date you met on site. Is that correct?
October 26th, I believe.
Okay, thank you. And has that stop work order, pardon me, it's getting late, remained in place since it was enacted or verbally stated?
Yes, no permits have been issued for any activity on this property since we met on site. And like I discussed earlier, I did suggest that if they'd like to begin the work to correct some of the violations, that they just submit a permit for what they would like to do, so that we can make sure that they're in compliance with everything that.
Thank you. And also, to your knowledge, is there any evidence that they took any actions once the stop work order was, you had communicated that? Did they continue work?
I am not aware. I don't believe so. Chris may be able to answer that better than me, because he was the one that has been on site the last couple of months. I'm not sure if any activity has taken place since. Chris, can you answer that?
I don't believe there's been any activity.
Okay, great. Thank you so much. And one thing I did want to ask is with respect to the stumps. I understood you to say that the ordinance precludes removing stumps for hazard trees, correct? I heard you correctly there?
Well, it's really for removal of trees within 100 feet is how we often like to handle that, unless it's for, the replacement of, a structure, for example, a non-conforming structure, if it's an allowed use that has a soil disturbance, an approved soil disturbance associated with it.
So with an approved project that it's, or say an approved stabilization project, that stumps do not need to be removed for that purpose, correct?
If someone gets a permit for a stabilization project, it is possible that stumps may be removed, depending on what the parameters of that project might look like. But if someone is replacing a non-conforming structure, for example, within 100 feet that requires a new foundation, and they have to cut 3 or 4 trees within 100 feet to accomplish that, then stump removal might be allowed for a situation like that. But if it's just for the removal of 2 or 3 hazard trees within 100 feet, then a stump typically is not allowed to be removed.
Okay. All right. Thank you. I think that's it for me. Appreciate it.
So board questions at this point?
None for me.
None for me.
None for me.
I've got a question or two. Alex, just to confirm. So the town, no one's saying that the jetty didn't exist. It's that there was a degree of repair beyond what would be considered normal or approved because it was a non-conforming jetty. It was essentially rebuilt or expanded. And that's what the violation, that's the premise of the violation for the fourth violation.
Correct.
Okay. And then there was some comment on the use of barge from Mr. Morse with respect to the optimal time to do some of this work being at the low water. Is that taken into consideration or is what you were saying is irrespective of when it may be optimal to construct or put riprap or whatever needs to be done, that the work should always be done at high water because that's the most likely time you could use a barge?
No, not necessarily. I mean, it may make sense to do the project at a time of the year when the water levels are lower, but that really all depends on the amount of erosion that's taking place and how tall the bank is. For example, if the bank's only a foot above the normal high water mark, is any erosion actually taking place below that normal high water mark? It really, I suppose, depends on what exactly they're trying to resolve or correct in the situation. But we didn't really get a chance to review that.
Right.
So I don't know. I really don't know, what that parameter might have looked like.
Okay. That's it for me.
Okay.
Any further comments from board members?
Nope.
Okay, Attorney Wyckoff, was there anything further on the presentation of your case?
No, not with regards to this notice of violation.
Okay, thank you. So at this point, I've got my procedural order here that we would allow rebuttals to any points by the parties. Then we would open it up to public comment, and then the parties would be provided an additional opportunity to address anything raised in public comment. So at this point, are there any, we'll turn it back over to Attorney Rachin. Do you have any further arguments or points of rebuttal to make?
No, I mean, I think what I'd like to do is just have a summation, and I don't know if this would be the appropriate time. And I want to keep it quick because I know that the hour is late and we've only not even made it through one appeal yet.
Sure, I'll defer to the parties if they want to do it. If you want to do a summation before public comment or after public comment.
Oh, you know what? I'm so sorry. I didn't realize members of the public. Why don't we wait? I will wait, certainly, because then if anything comes up in that time, I'll be able to address it, two birds, one stone.
That makes sense. Attorney Wyckoff? Okay, so Mr. Chairman, at this time, I'd recommend you make a motion to open up public comment.
That sounds good. I will do that. Make a motion to open public comment. Do I get a second on that?
I'll second it.
Okay. Tom, approval of opening public comment, yes or no?
Yes, please.
Craig, approval, yes or no?
Yes.
Fred, approval, yes or no?
Yes.
David Murch, also approval. So we will open up to public comment. Is there anyone in the public here tonight that would like to speak in favor of this administrative appeal?
Just so I can clarify for the record, do we have anybody monitoring hand raising? How are we doing this?
I believe our town office Zoom administrator is looking, but I don't know for sure. I'm not
seeing anybody.
No. So I'll then ask, is there anybody here in the public tonight that would like to speak in opposition to these, to this particular administrative appeal? Not seeing or hearing, I'll ask, is there anybody in the public here tonight that is taking a neutral stance with regards to this administrative appeal? Would they like to speak? Seeing and hearing nothing, I will then go ahead and close public comments. So, Attorney Rachel, if you'd like to provide your summary.
Sure, thank you so much. So as I said at the beginning, there were sort of three major overarching themes here. Basically, who's responsible? And I know that much has been said about that, but I did want to just read from the governing statute here. Talks about liability for violations. Any person, including but not limited to a landowner, the landowner's agent, or a contractor who violates the ordinances shall be liable. And I think it's really important to note that it doesn't say the landowner and, you know, the landowner's contract. It says the landowner or. So the fact that there's an or, not an and, doesn't mean that the landowner has to be responsible. There's a full scale or scope of people who can be found responsible. And I think I would, you know, just say contrary to what the town is arguing, the landowner doesn't always have to be responsible. Sometimes they are, often they are, most of the time they are. But in this case, I would submit he is not. With respect particularly to the non-permitted work. I think, as you know, the code officer said that this was an expert, and he was, frankly, I think his words were disappointed. And it was surprising that somebody with such expertise would go about this work without having secured appropriate permits. So I'll leave it with that. With respect to the areas which we strongly submit that were not violations, they were the creation of the beach. We talked about that, the expansion of the jetty. And I think it's important to understand, this is not, I think there was mention made that this was I just took a note here, it's a non-conforming jetty. This is a legally existing jetty, and it's a functionally water-dependent use. And this was simply about picking things up that were on the sides that had fallen away because of, you know, ice action or wave, I should say ice and wave action, and put on top. That is not an expansion. And finally, this notion of the alleged failure of the use of the barge, you know, we submit that it was not a violation for all the reasons why that Mike Morse had explained. And most importantly, again, this is kind of the big theme of our case here, is this notion of duplication. I think it's really important to concede that we should have obtained a planning board, a permit for shoreline stabilization work from the planning board. But that permit would have encompassed the earth moving, the vegetation removal, and the trees. And I think that it's really critical to understand that. And so to that end, we're asking, and I'll just give you the numbers here as far as what we are looking for. We believe that because of these duplicative violations, that we stipulate to violations 5 and 11, but combine them as one, and that we strike violations 1, 2, 7, 8, 11, 13, 14, and 15, because those would all be part and parcel of the planning board permit, which we have applied for, and which we are, you know, as you heard Mr. Morse say, that he believes in his opinion, we will be entitled to. So that's our case with respect to violation number 1, and I will rest with that unless there's any questions.
Can you repeat to me again the violation?
Oh yes, I was going fast. So we stipulate, as I said, to violations 5 and 11, because in our view, those two are the flip side of the same coin. Under the land use table, it talks about, you know, this is under 15C. So 15C, sorry, not the land use table. Under 1417B, that deals with piers, docks, wharves, and uses extending below the normal high water line. for permanent uses. Again, we say that that was the provision that we were supposed to go to the planning board. Now, if you flip that's section 1417B. If you flip to section 15C, and those are the standards, again, verbatim, the same as 1717, piers, docks, wharves, boat launches, and uses extending over the normal high water. You go to 15C. What do you see? What do you hear? Piers, docks, wharves, bridges, and other structures or uses extending below the normal high water line. Okay, so under section 1417B, you are required to go to the planning board. Under section C, go down to C12, vegetation may be removed in excess of the standards to conduct shoreline stabilization with a planning board approval. And so that is what we're saying, is that, you know, these shoreline stabilization projects are going before the planning board, and part and parcel of them are all of those other violations. So to your question, we stipulate violations 5 and 11, but combine them because they're the same. And we ask that you strike 1, 2, 7, 8, 11, 13, 14, and 15, because those would all be encompassed in the planning board process. All those activities, I should say, that those violations discussed would be encompassed in a planning board approval.
Got it. Thank you very much.
Thank you.
Alex, Attorney Wyckoff.
Yes, I'm happy to sum things up. So first, in terms of responsibility, management controls is clearly responsible for these violations. The contractors were its agent. It directed its agents to do this work, and it's on the hook for these actions. It needs to be responsible for them. Now, the jetty, the photos speak for themselves. Okay, you can look at the photos and you can decide whether or not that was just repair and maintenance for that jetty. I think the photos speak for themselves. That's just not what happened. It was much more than that. I'm not going to rehash the duplication. I went through that in great detail. I don't need to go through that anymore. Now, I think it's important to realize that what they're saying is all of these violations should just go away, because if we had, if we were doing the shoreline stabilization project and this is all included in there, well, the problem is there wasn't a permit for it. That process never happened. No application was made. No one had a chance to look at that application and provide any feedback. No one for the town had any chance to say, you know what, this isn't right. This should change. That should change, etc. None of that happened. So that argument just has to go away. That there was no permit for this project, and each of these individual violations that are included in the notice of violations they're all violations, and they're all there, and they all need to be recognized. So here, the town respectfully requests that the board adopt the proposed findings of fact and conclusions of law that were submitted by the town, that the board reject this appeal, and that the board uphold in its entirety the notice of appeal that's the subject of this appeal. Thank you.
I thank you. So, Attorney Wagner, next step.
So at this point, we've heard from all sides, and the public's been presented an opportunity to respond as well. So I think the next steps would be to close the introduction of close the evidence for this matter, and that would mean the record is complete and no further evidence could be introduced. So before the board does that, I suggest a motion and second, and then I think the board should discuss if it has a clear understanding about the record. So I think if there's any question about what's in and what's not in the record left, we should address that before we close the record. So I guess I pose to the board is there any question about what's in the record, or do you have understanding of that based on what's provided on the website and what was submitted today that wasn't excluded.
I have a question. I think that's related to that. David, do you want to go ahead or?
Oh, you go ahead.
Yeah. Just as the board is the intent, and it sounds like it is, if I'm understanding the procedure as it's been outlined, is the intent to not visit a lot of times when it's not an appeal, we would go look at the site, and are we looking to not do that at all? And the reason why I think that might matter is it sounds like some of these violations are what's a beach, what's not a beach, what's a jetty, what was the, some of the pictures are very compelling, some are less compelling, and I'm curious procedure wise, where is that evidence that we would collect in the normal course of the ZBA?
So I can weigh in on that. So this is a de novo hearing, and it's certainly within your authority if you wanted a site plan. A site review to call for one. I'd give the parties an opportunity to respond to that idea, and they can certainly object or argue about that. But I think it's within the board's purview to make a motion for that. If you do, I would recommend keeping the record open.
Right.
And sorry, just in addition, then table the matter and schedule a site visit. And we'll need proper notice for that site visit.
So I mean, that would be my preference. I don't know how everybody else feels, but
I mean, personally, I'm good with the photo evidence that was presented. I don't, from my own perspective, don't feel the need for a site walk. I open that up to Tom and Fred.
This is Tom, because I asked that same question a month ago, and at that point, I thought it might be advisable, but with all the evidence presented, I don't think we need a site walk.
Fred, your thoughts?
I always say a picture is worth 1,000 words, and I think the pictures are speaking for what we're seeing. I don't think we need to go out there.
So I think there's a consensus on the board, so it's up to you, Member Dean, if you want to nonetheless make that a motion and have a second and then call a roll call vote on it, or
sure, I'll make a motion for a sidewalk to, I guess, to table or plan for a sidewalk, but I suspect we won't get a second. But yeah, I'd like to make a motion that we.
And do we have a second for that? And that's just for purposes of getting it up for a vote.
No.
Okay. Seeing no second, the motion fails and it won't go for a vote. So are there any other discussions about reasons to keep the record open for additional evidence, or any questions about what is in the record? And just so I repeat, so I'm clear for the record, my understanding of the record is what is on the link that was included in the agenda and circulated, all the documents on the website, in addition to what the materials Attorney Wycott submitted earlier today. And I'm not sure if they are on the website or not at this moment, but I would consider those part of the record. I'm getting a nod that they are. So that's my understanding of the record. So are there any further questions from the board about the record?
None from me.
Okay. And I'm seeing head nod shaking from the parties as well. So I assume we're ready. Okay. So at this point, I'd suggest a member make a motion to close the record for this appeal.
I'll make a motion to close the record for this appeal.
I'll second.
Okay. And any further discussion? And I suggest you call the vote, Mr. Chair.
Tom, yes or no to close?
Close.
Greg, yes or no to close?
Close.
Fred, yes or no to close?
Close.
David Murch also to close, so unanimous on that.
So at this point, I think Mr. Chair, I'm going to direct this to you, and you can certainly direct it to the board. I think you need to make a determination as to whether you want to proceed into deliberations tonight. Certainly the board could do that, or it would be within the board's discretion to choose to take it under further consideration to give the board members time to review the record and everything that was submitted today, and we can resume deliberations at the next meeting. I do recognize that it's 10:30, but that's entirely up to the board, and you can certainly solicit positions from the parties as well.
Sure. I mean, I know it's 10:30, but it's all fresh. I'm ready to continue and get this resolved tonight, if at all possible.
I'm in favor of getting one done.
Yep. Attorney Richen?
Thank you. And just from a procedural standpoint, I think it would also help the parties, because so much of the subsequent appeal will kind of rise and fall on what you decide on some of these issues. So, coffee is available, and anyway.
Understood. Greg, Fred, feedback?
Yeah, I'm more on the indifferent side. I don't necessarily value the expeditious nature of it as much, obviously, since I wanted to do a sidewalk. But if we want to do that, I'm not opposed to it. So,
Fred?
I'm okay with continuing. Yeah.
All right. Attorney Wyckoff, Alex, you guys good too?
Yes.
Okay, very good. So we shall continue.
Okay, so my recommendation for beginning deliberations is to, I think it's important to start with determination of timeliness. And then after that, identify the issues that have been raised on appeal. And we'll take those one by one. And for each issue, we should identify articulate the issue, identify the applicable standards, and then have a discussion of the arguments that were raised on both sides and the evidence in support of those respective arguments. And then when, I think it makes sense to have a free discussion of that. And then when someone is ready on the board to make a motion, I'd suggest a motion that states a conclusion of law, that we all violations should not be vacated because they name the owner or something. Sorry, I'll articulate that better when we get to a particular. I don't want to start in on a particular issue, but yeah, state inclusion law and state the particular facts in support of that. And so I'll help you craft that motion as we go along. But that's sort of the process I see laying out. So I suggest that we first take up the issue of timeliness. So, Mr. Chair, I suggest you pose that question to the board if we think we have a timely application for this appeal.
So when you're talking about timely, you're talking in the terms of it being submitted within the correct time frame?
Yes. Was this submitted?
Yeah, and we did look at that at our last meeting prior to tabling it, and it was determined that the application was submitted in a timely manner.
Okay, my mistake.
No, that's fine. You weren't here last time.
There you go. So then I suggest we take up the first issue. In Attorney Wycott's closing arguments, he did point out his proposed findings of fact and conclusions of law. That's certainly one way the board could address this. Or I could identify issues for you and guide you in that way. Do you have you as chair, do you have a sense of how you want to approach this? I don't want to dictate to you too much.
Well, I would say, given the amount of information that I am processing in my head right now, if you are able to help direct us to where we should go, that would be much appreciated.
So I would direct you to the applicant's statement of, or not the applicant, I'm sorry, the Attorney Wycott's statement of findings of fact and conclusions of law that lays out the applicant's positions. I think we should have that in front of you. I think you should also have the notice of appeal submitted by the owner's attorney, Attorney Rakin, and the notice of violation. I think that will help us identify the issues. And I suggest to you that the first issue for the board to discuss is applicant's argument that all the violations should be vacated because the owner relied on its contractor to obtain the permits.
Wow. So gentlemen, I will be looking for your input on this. From my own perspective, while I understand that, that somebody was hired to obtain those permits, it would still seem prudent to ensure that those permits had been obtained and are proper. So I don't believe the violation should be vacated. As a result of that, I do think that the appellant has an obligation to confirm that those permits had been obtained. Again, I'll put it up to you folks for feedback as well, please. Tom, Greg, Fred.
I'll speak first, I guess. I agree with you, David. This is, we're dealing with people that are educated, that own businesses, that obviously probably own other properties. So, myself, I got a lot smaller things, and I still verify that I have permits before I get anything done, especially in the shoreland zone.
I agree too that they should have made sure that the permits were taken and applied for. Again, especially where you are near the water and all that. So I agree.
Craig.
Yeah, I think that we're not gonna. I'm not in favor of vacating all violations under that pretense.
Okay. So Attorney Wagner, I don't know, in the past, when we've gone through at least ordinances, we've taken sort of like a vote as we go through each one as all in favor of, skipping or approving this, or, it's sort of, we get an idea of where we're all at for the record. I don't know if that's necessary here. We weren't necessarily making a motion. We were just sort of confirming how we would respond to a particular item.
Sure. Yeah, my recommendation would be that we should make votes on each issue. I don't think we need a vote on every finding of fact in support of that conclusion, but I think as long as there's a motion that identifies the conclusion of law and the issue of facts in support of it, I would recommend an overall vote on that. And then at the end, when we've gone through all the issues, the board would take a final vote, and that would be the final decision.
All right. So not sure if I'm understanding quite correctly, like this very first one, all violations should be vacated. The board is sort of in an agreement that they should not be vacated. Yes, we've talked about it. Do we need to do some sort of informal hand raising just to sort of confirm that?
Sure. So what I'm saying is I think we should take a vote on that.
Okay.
Are you asking, do you want
Need to be okay. Does it need to be motioned, or we just sort of just do?
Yeah. So what I would say is, could I would have a motion to deny the. Give me a sec to articulate this. So I think the conclusion here is that because MCL is the property owner and authorized an agent to perform the work, MCL as owner is responsible for the actions of the contractor and therefore is properly named in the notices of violation. So can I have a motion for that conclusion of fact?
I would love to say that. Do I have a motion for that conclusion of fact? I will make a motion. Do I have a second?
Seconded.
All right. All in favor, Tom, in favor or against?
In favor.
Greg, in favor or against?
In favor.
Fred, in favor or against?
In favor.
David's also in favor. So,
And I'm doing it a little bit backwards, but I'd like to just be clear on the reasons for why. So what I heard, and these will be the board's findings. So what I heard was that MCL was the principal and authorized an agent to perform the work.
yes, yeah.
And Attorney Wyckoff raised a number of provisions in his arguments. I would direct you to page 9 of his proposed statements of findings. And the conclusion section cites a number of provisions as the board reviewed those and concluded that it's proper to name an owner.
Yes, I mean, I had read this and having reread it, I am in agreement with what was presented by Attorney Wyckoff. Gentlemen,
And does anybody on the board disagree that that was part of that's part of our findings of fact in support of the conclusion that was reached? I'm seeing no disagreement.
none for me.
None for me.
None for me.
Greg,
So-
you good?
No, I'm good.
Okay.
Sorry, I thought we were asked if we disagree, but no, I do not disagree.
Okay, got it.
Okay, so I think we have a conclusion of law with supporting findings of fact and a unanimous vote to that effect on that first issue. So I would suggest the second issue here is the argument that violation 1 should be vacated. It relates to soil and water conservation practices, which are allowed in the zone without a permit. Additionally, there's no explanation or evidence that the work was not conducted.
Well, I do believe the evidence was provided that an erosion and sedimentation control plan was not provided.
So I think let's start with identifying the applicable standard here for violation.
Sure. Sounds good.
So does anybody want to flag that, or I believe it's section 15U1 relates to filling and earth moving.
Oh, yeah, of course. Yes. So, yeah. Shoreline zoning procedures, section 15 land use standards, U1 erosion and sedimentation control, filling, grading, lagooning, dredging, earth moving, and land use activities shall be conducted in such a manner to prevent erosion and sedimentation of surface waters to the maximum extent practical. All activities which result in unstabilized soil conditions and which require a permit shall be developed in accordance with an erosion and sedimentation control plan prepared in conformance with the requirements of the Maine Erosion Control BMP's Bureau of Land and Water Quality, Maine Department of Environmental Protection, March 2003, and subsequent revisions thereof. So, gentlemen, do we feel that evidence has been provided that this was not applicable? Anyone?
So I suggest you could look to page 7 of the applicant's proposed statement of findings, fact, conclusion of law. And there are several recommended findings. The first is that filling and earth moving activity of more than 10 cubic yards took place. So based on the evidence you've reviewed, do you think that finding is supported? Is that a finding that the board can make?
That is a finding I can make, yes. Tom, Greg, Fred?
Yes, I think there's more.
I agree.
I agree.
Yep.
And is there particular evidence to that? Is it the CEO's testimony? Is it photos that were submitted?
Oh, well, Exhibit A is pretty, well, the various photo evidence makes it clear that that this took place.
Does anybody find any contrary evidence persuasive? The next finding is that the work was not done in a way to prevent erosion and sedimentation of surface waters and was not done in accordance with an erosion and sedimentation control plan. Is that a finding that you believe is supported by the evidence? And I think you should discuss what evidence you think does support that finding.
Yeah, so I know that Alex reported that there was no erosion and sedimentation control plan submitted. So that's clearly whether or not the work was done in a way to prevent erosion and sedimentation of surface waters. And I can't speak to that, at least at this point, but we did get evidence that it wasn't done in accordance with the plan. Gentlemen?
Because there was no plan submitted.
Correct, yeah.
I agree with that.
So a related fact there would be that the work was done without a permit.
Right, yeah. And then it also, states that nothing was prepared or submitted. So that's the two. Well, so the only thing I can't speak to right at the moment, we should probably talk out loud about, is the work was not done in a way to prevent erosion and sedimentation of surface waters.
I think Alex pointed out that the whatever the fabric is down at the water was not tagged, or whatever term he used, not tied in to control the runoff.
Yeah, I remember him stating that as well. Yeah, you can see it in Exhibit D.
Yeah, I mean, you also got Exhibit E with the excavator almost in the water.
Yeah, I guess with that, I don't know what the appropriate version of that is. I know it was claimed that it wasn't appropriate because you could see kind of flapping or folding over. That's the only counterpoint I would think we should consider is, I mean, if you showed me another picture and said this was good, I would probably not. Probably say, okay, it's good. So kind of just deferring to Alex on that.
Yeah, I guess we have to go based on the evidence that was presented to us tonight. We didn't hear any counter argument from the appellant with regards to that, so.
I don't know, I guess I'm used to seeing hay bales to keep the runoff from going down into lakes and streams and stuff. So I didn't see any evidence of that.
So, given these 1, 2, 3, 4 items, in this findings that's been provided by Attorney Wyckoff, I believe that all of these are consistent with what we've heard tonight.
So can I suggest, are there any additional findings that you would like to see besides the 4 that Attorney Wyckoff provided? For instance, I think the board raised the issue of there was no fabric provided. No erosion control. The measures were not adequate in the opinion of the code enforcement officer.
Yes.
Okay.
I believe that should be added.
So why don't we do this time? We'll do a motion on the findings, and then we'll do a final motion on the conclusion based on that. So can I have a motion that those 4 findings plus the additional one I just read be findings of the board?
I would make a motion to that regard. Do we have a second?
I'll second.
Okay. Any further discussion on this, gentlemen?
Nope.
No. All right. So an agreement that with these findings, Tom, yes, an agreement or no?
Agreed.
Greg, an agreement or not?
Agreed.
Fred, an agreement or not?
I agree.
David, an agreement as well. So unanimous on that one.
Okay. So then I would suggest a motion that the board concludes as provided in notice of violation. 1, filling in earth moving occurred in violation of section 15U1 for the finding based on the findings of the board.
Do I have a motion for that? Anybody?
So moved would be adequate.
So moved. Do I have a
So
second?
moved.
Do we
Nice
have a
second. So I think any further discussion?
Mm,
I think it's
Good.
time for a roll call, Mr. Chair.
Thank you. Tom, in agreement? Yes or no?
Agreed.
Greg, in agreement? Yes or no?
Yes.
Fred, in agreement? Yes or no?
Yes.
David's in agreement as well. So we're unanimous on that one.
Bear with me a sec.
No. No problem.
So I think the third issue here is that violation 4 should be vacated because the jetty was pre-existing and the activity that occurred is consistent with repair and maintenance.
So we have shoreline zoning provisions, section 14, table of land uses, number 17B, permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. So referring to the findings submitted by Attorney Wyckoff, has entered here, the town has no record of a planning board permit for the jetty. I believe the appellant has acknowledged that, as well as Alex. Gentlemen, you in agreement? Is that your recollection as well? Okay. Town has no record of the jetty having a permit from the Department of DEP. And I don't remember if I heard about that. Trying to find the notice of violation for
Yeah, there's no permit.
permit. Okay, thank you. Appreciate that. The work done on the jetty was not merely repair maintenance. Vegetation was removed from the jetty. Rock and sand were added below the normal high water line. Boulders were removed from the shoreline and relocated to the jetty, making the rock show that they were moved during the project, and the jetty is clearly larger.
Just to add a comment, I don't know that it needs to go in here, but a jetty doesn't really fit under shoreline stabilization, I don't think.
Is
Yeah,
there anything in the record that you'd want to point to that a jetty is not consistent with shoreline stabilization activities?
Do you have anything specific to that, Tom?
No, I'm just, if they had gone for a permit to stabilize the shoreline, I'm not sure enlarging jetty would have ever been part of that plan.
the only thing I can't really tell, to be honest with you, is I think this is the like least compelling imagery, because of the angles are so different, and the testimony about the water levels being different is really hard to tell. And this is the primary reason why I wanted to look at the jetty is it definitely was at least repaired, and whether or not it was reconstructed, or more enlarged, or you know, just novel construction. I can't really tell, to be honest with you. The imagery in the NOV and exhibits, I think it's well, actually, most of the exhibits, they're kind of before and after aren't great angles, unless you guys see one that really nails it for you. I actually find the argument that the water levels changing and repair of an existing non-conforming structure to be fairly reasonable counterpoints to that violation. I'd love to hear, you guys might be more confident, but I'd love to hear your thoughts.
Yeah, Greg, I am in agreement with you on that. The only thing I refer to is what was submitted documentation, which is the notice of violation issued by the Department of Environmental Protection. And there's a numbered list of items that they identified. And number 3 on that list was a newly expanded permanent structure, jetty, was observed below the normal high water line of the resource, approximately 40 feet long and 15 feet wide. So it was also identified in the DEP's notice of violation. But I would agree with you with the photo evidence. I have a hard time as well.
Yeah.
Considering that wasn't necessarily repair.
I guess my point being that there was no need to do any work on the jetty. It wasn't really part of shoreline stabilization, and it's obvious that a certain number of boulders were, moved to make it more useful as a wharf or something. But and I think Alex also pointed out that some vegetation was removed potentially also. So.
Yeah, I hear you. It's not obvious to me, I guess, based off from the DEP saying that they agree. It would have been great if they could have provided the independent imagery or something that draws that conclusion for them. but I put most of that weight on the images, and it's just hard for me to tell if the water lines, if this could be rocks that are 2 feet underwater that we're looking at that are now exposed, or I can't tell. These white dotted lines mean, are not great to say that this is an accurate assessment of what actually happened there. It's hard for me to say, to be honest with you.
Yeah, information provided by the appellant says the jetty mentioned was pre-existing in the area at issue. The contractor simply picked up some stones that had slipped to the side and put them back in place. There was no use established that would have required a permit, nor was there an expansion or an enlargement of the existing use. Said work constitutes repair and maintenance, which does not require a permit.
Yeah, fair.
I guess I'd ask our advising attorney there, is any work below the normal high water line require a permit, regardless of whether it's a jetty or anything else?
Yeah, so I think we need to turn to the standards at issue here. So let me pull up. So I think let's go to section 1417B. So planning board permit is required for a permanent pier, dock, wharf, bridge, boat launch, or other structures or uses extending over or below the normal high water line within a wetland. The other provision at issue is, as I think the board found that this is a non-conforming use, is the expansion of a non-conforming use requires a permit.
Yeah, I can't.
So does the repair of a non-conforming require a permit? Is that the conclusion?
Say that again.
Would repairing a non-conforming structure require a permit?
This is, yeah, I mean, there's no indication that for the appellant says said work constitutes repair and maintenance, which does not require a permit. I'm at a loss for trying to find.
Hey, David,
Yeah,
can you look at Shoreland zoning 12C? I don't have it right in.
section 12. Non-conforming structures. Yeah, I'm on 12C. What are you looking for specifically? Because I'm on 12C, non-conforming structures, talks about expansions, foundations, relocations, reconstruction or replacement, change of use. Is there something specific you needed from this, Tom?
He's muted.
I'm looking at something that said a non-conforming structure like a jetty here, I guess, or as an example, can only be expanded, reconstructed, or replaced with a permit.
Are you seeing that or are you looking for it?
No, it was in Attorney Wyckoff's write-up, I think.
So if you look at C1, non-conforming structure expansion, a non-conforming structure may be added to or expanded after obtaining a permit from the same permitting authority as to that new structure, in which case that'd be the planning board.
So if it wasn't expanded, it certainly was reconstructed. And on top of that, it's below the normal high water line.
Non-conforming may be added to or expanded. So that's the question. Was it added to and expanded, or was it just simply repaired back to its original condition?
I mean, I think that's the applicant's argument.
Right. And I can't personally, I agree. I can't find evidence to indicate that it's not repaired back to its original form. So I guess kind of comes down to the point of this third item. The work done on the jetty was not merely repair maintenance. Vegetation was removed, rock and sand were added below the normal high water line, boulders were removed from the shoreline and relocated to the jetty. Markings on the rock show they were moved during the project, and the jetty is clearly larger. I cannot be convinced of that.
So I think there's also another statutory standard at play here. The applicant makes an argument that 38 MRS 480 Q2 applies, and let me pull that up and read it to you. So that states a permit is not required for maintenance and repair of a structure. So in full, maintenance and repair of a structure other than a crossing in, on, over to adjacent protected natural resource if erosion control measures are taken to prevent sedimentation of the water. There is no additional intrusion into the protected natural resource, and dimensions of the repaired structure do not exceed the dimensions of the structure that existed 24 months prior, or the rest of it I'm going to suggest to you is not applicable. So the argument in response to that was that that provision does not apply because the town does require a permit for the activity. So I think you need to make a determination as to whether that statutory provision applies or if it doesn't apply, because the ordinance here does require a permit for the expansion.
But yeah,
Like I said, I cannot be convinced that this was expanded.
just the perspective of the pictures that have been provided as exhibits are just extraordinarily like hard to reason about. You have one that's a waterline picture at one time of the year, and you have another that's an aerial picture that's at a different time of the year.
Right.
And to me, the argument that this is an existing structure that we needed to repair is fairly compelling given the evidence that's been provided. That's kind of my point.
So could I characterize that as a motion that the violation 4 should not be upheld because the evidence does not support a finding that the jetty has been expanded without a permit in violation of section 14 subpart 17B.
Yes. I'm just checking this numbers that, yeah, 1417B, yeah.
Yeah.
And the subsequent,
Yeah, and I guess so let's modify that slightly. 1417B or 12C, which is the expansion of a non-conforming use.
yes, exactly.
So is there a second on that motion based on those findings?
Yeah, I will second.
Okay, is there any further discussion on that?
Nope.
So I suggest a roll call vote.
So this is a roll call vote to strike, is that correct?
Right, so a affirmative vote here would agree with the applicant, the appellant, that notice violation 4 should not be upheld. There
Okay.
would be no error.
So Tom, yes to not being upheld. That's not, it's kind of like didn't come quite. So yes to striking this, or no?
You could phrase it as that.
I'll say no.
So you want to include it. Okay, Greg, yes to striking, no to include.
Yes.
Fred, yes to strike, no to include.
Yes.
Yes to strike. David will also say yes to strike. So that's 3-1. So majority on that one to strike. All right.
So having a brief moment of panic here. Is this being recorded?
Yes.
It is? Okay, because I'm not seeing the little recording sign.
Oh, it's supposed to be. Raymond Town Office, can you confirm for us?
Yeah, or Sandy.
See that the broadcast studio, which is the other one that says town office, I see that there's still, so I'm assuming that Sean's still recording.
Okay, so Zoom is not the only means by which this is being recorded. So that's
Yeah.
why. Okay.
No, broadcast studio.
Okay, just clarifying as I'm trying to write this down for purposes of this decision later. So
Glad you are.
yep, so let me just make a couple notes.
He's come on chat and said he's definitely recording.
Good.
Thank you. Okay, so I think that resolves the third issue. So I suggest we move to the fourth issue, which concerns notice of violation 5.
Yeah, piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland without a permit from the planning board. Shoreline. Shoreline has been enlarged, expanded without a permit from the planning board. See Exhibit C. Ordinance is section 14, table of land uses, number 17B. Permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within the wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. And finding of our conclusions here, findings proposed anyways, is the shoreline was expanded. There are large boulders that did not previously exist. The shoreline is larger than before. the shoreline protrudes in front of the stairs, whereas it did not previously, and the shoreline by the jetty and the stairs protrudes further into Sebago Lake than they did previously. This work was done without a permit. So large boulders that did not previously exist. Gentlemen, if you are assisting me with this. Try and see what Alex referred to. He's referring us to Exhibit C.
Now, I would remind you, I think I have in my notes, and Attorney Rachel couldn't correct me if I'm wrong, but I believe the applicant did stipulate to violating 5 and 11.
They did, you're correct. Looking to have number 11 vacated though. So I appreciate that you brought that up. So.
I did see Attorney Rachen's hand. I don't know if you want to acknowledge her, Mr. Chair. There's certainly no, the board is within its discretion to ask particular questions of the attorneys.
Yeah, Attorney Rachel, if you want to clarify for us, that would be wonderful.
I'd be happy to. So what I did say is that I did stipulate to 5 and 11, but said that they should be combined into one, essentially, because they are, as I said, I think flip side of the same coin.
Okay, very good. Thank you. So if number 5 is acknowledged, then we can either refer now to number 11, or we can wait until we get to number 11 and choose to review it then. I would say let's go ahead and see if these two can be combined, since we are sitting on this topic. Just trying to find it here. Hold on 1 second.
So if I may suggest, I think that I think it makes the most logical sense here to approach the violations that have been raised, that have been challenged on appeal, take them in turn. And then we can address the larger procedural arguments that were raised, and the larger argument about there being duplication, and the board should combine those items. So in essence, following the issues that are laid out in the applicant's proposed findings.
That works for me, and I appreciate that feedback. Okay, so
I guess what we can have then is a motion to find to uphold notice of violation on number 5, based on the it's been stipulated to.
yeah, that's good. So yeah,
So
and I will second that. Any further discussion, gentlemen? Very good. So Greg or sorry, Tom, in favor of keeping this one?
In favor.
Greg, in favor, yes or no?
yes.
Fred, in favor, yes or no?
Yes.
David's in favor as well. Unanimous on that one, keeping that in place. So it looks like what, number 7, request for that one to be vacated.
I think we're on violation number 6, construction of a beach without a permit.
Yeah, so my question is, do we need to go through the ones that aren't in contention, or because per Attorney Rachel, I don't see that number 6 is one that was requested to be vacated.
No, it is.
Number 6 was in that list. Okay, I'm just going by what she listed out at the end. He says how I heard it.
Oh, I see what you're saying. From the, I think it's in the appeal though.
It is in the appeal, yeah.
All right,
Yeah.
all right, yep, I do see it.
Yeah, I think there was just a lot of numbers. Maybe we
Yep,
skipped
all
over.
right. Thank you, Greg. So
David, I think Councilor Ration had something.
oh, yeah, Attorney Rachel, if you have something.
Thank you. I'm just trying to be helpful and not belabor anything. What I wanted to make sure is that when I was listing out those numbers that you had asked me about, Mr. Chairman, I was talking about those that should be consolidated, but there's separate ones like the beach and the jetty. I didn't ask to be consolidated because we disputed those particular violations.
Okay,
So,
very good.
so the beach, I think violation 6 is the beach, and that's why I didn't ask for it to be consolidated.
Understood. Thank you for that clarification. So, number 6, construction of a beach without a permit. A beach has been constructed without a permit. See Exhibit C. Under Shoreland zoning provisions, Section 15, land use standards. Item O, beach construction. Beach construction on any great pond shall require a permit from the Department of Environmental Protection. Beach construction on any river, stream, or brook capable of floating watercraft shall require approval from the Department of Environmental Protection. From the appellant, they are indicating that any support could touch to identify what is meant by beach, which term is not defined in the Shoreline zoning ordinance. Review of Exhibit C and the notice of violation submitted to establish that a beach was constructed does not show a beach as the term is customarily defined. See dictionary.com, which defines this term as expanse of sand or pebbles along the shore. Rather, both the before and after photos show the access to the water is provided by stairs, and there is no expanse of sands or pebbles along the shore. Rather, they're just large pieces of riprap. There is no beach. So the findings that we are looking at here is a beach composed of stones and rocks was constructed without a permit from the Department of Environmental Protection. So I know in the original notice of violation, in Exhibit C, and I can see it in the second page of Exhibit C. I mean, if I recognize that Alex submitted another photo earlier, but just looking at Exhibit C on the second page, the bottom photo, I mean, there does look like there's a little bit of a beach area down there. And I would agree with what Attorney Wyckoff had indicated, that a beach to me, especially growing up on the ocean, that can be a stone rock beach as well. It doesn't have to be sand or pebbles. And then the further submission of a picture by Alex made it clear that there was definitely some removal of rock there to provide for certainly a beach-like atmosphere.
Slide 6, I think, David, if you're
Was it?
in his presentation, might be the slide that you're referring to, just in terms of.
Yeah, it just showed sort of the riprap on both sides with that flattened out. Yep. So,
I don't know, but
do we have evidence of?
to me, if they're going to make a beach, they would just remove all the rocks. Like, I think that's just kind of maybe the byproduct of another violation, but that's a stretch for me. I think we have to decide if slide 6. I think it'd be prudent if everybody pulled it up and took a close. Is the best view of it? Like, is that a beach? That's my take.
So I think part of this, I think this discussion is a little bit twofold. First, you need to make a determination that, do you have a definition of beach? What is the meaning of beach? And then that's a legal determination for you to make. You've given some competing definitions of dictionary definitions, but also some common sense arguments of what a beach means in Maine. And so I think you need to make a determination: does a kind of beach include pebbles and rock fragments and still meet the definition of beach? And if it does, then you need to make a factual determination of, does the evidence presented here show that a beach was constructed?
I guess we can address the definition of a beach. Again, growing up on the ocean, a beach for me consisted of large rocks. So
I think we're discussing what a manufactured beach could look like. I mean, that might be might be a distinction we want to make, because the violation is that there was a beach created. So we're not just talking about beaches. I think we're talking about manufactured beaches.
Yep.
Manufactured beaches, I think, would be a little bit of a higher bar. I totally understand there's a broad spectrum, but that's probably the problem with the ordinances more than it is a problem with anything else. Like, if you want to find people for building beaches, define what a beach is. It's my take, but otherwise we're sitting here debating what a beach is.
I guess that's the thing, is we don't have a definition of a beach. We just have dictionary definitions.
Yeah.
So I
Hey,
think the beach is applicable to, according to the ordinances, is beach construction on any river, stream, or brook as well. So, well, I guess, yeah. So, I mean, it's, although I guess there's a distinction of a beach on any great pond. So, I don't know. To me, I look at that picture, that's a beach in terms of what I would, I'll take out the fact that we're talking about a beach in terms of this appeal at the moment, but looking at that, I would view that as a beach. I believe a beach can include sand, larger rock. So,
Right, David, if this is Tom, if we're looking at the same slide that Alex showed in his presentation, that large flattened area that's full
yeah,
of sand and gravel and whatever,
yep,
obviously wasn't there in any of the other previous photos. So, I mean, the 4 photos. So whether you call it gravel or dirt or sand or whatever, it's different. And it's somewhere people can walk in ankle deep water, probably at, when the Sebago's filled up.
Right, but I think like there's violations for moving stuff, and there's a specific violation about creating a beach. It really does matter, I think, if it's a beach or not. Like, there's a separate violation for moving soil or cutting, vegetation, and kind of terraforming in general is covered quite specifically. My understanding of what we're evaluating is this actually a beach? Like,
I think first off, we have to get a definition of what is a beach, right? So, I mean, given just in general, forget about whether or not this is actually a beach. Is what's presented here, could that be considered a beach? I mean, like I said, my opinion is yes, given my summers on living on the ocean. But then again, we're talking about a great pond, so.
I think what happened was when the other work being done, it's definitely increased the size of what was there before. I mean, there's obviously there was no sand and stuff brought in to create a lake beach there, but there's definitely been rock moved and, giving it a bigger area so you can put, lawn chairs or or access the water easier than they could have when walking over the rocks from before. So again, it's what do you call a beach? You know? But it's definitely been increased.
I hear what you guys are saying. I just think it's not quite right. I think I sound probably pedantic at this point, but it's constructing a beach, and if a beach was being constructed, I don't know why the rest of the stones would be left there.
So let's focus on first just the definition of a beach. For the applicant, they're saying, they're quoting dictionary.com, expanse of sand or pebbles along a shore. I'm trying to see what was defined by the town, and I'm not finding it here. I thought there was a definition that they provided, but I'm not seeing it immediately.
Mr. Wyckoff, he presented, I think it was like Merriam-Webster's, and it had pebbles involved in it to some extent.
Yeah, I cannot.
Or Alex did, I don't remember, but there's clearly a broad spectrum of definitions of what a beach is.
So what do we agree on as a board? I believe a beach can consist of pebbles, sands, and rocks, consistent with what we're seeing in this slide 24 here of Alex's presentation. Tom,
I agree with you, David.
Fred, I mean, just from a visual perspective.
I mean, it's definitely been increasing. It looks like a beach to me. I mean, it just don't have the definition of sand onto it. You know, it's definitely been increased.
So Greg, just in terms of strictly a definition.
How would I define a beach?
Yeah.
Sand that continues out into the water.
Okay.
So, Mr. Chair, maybe I would suggest you or someone make a motion to uphold violation number 6 because you find a beach composed of stone and rock was constructed without a permit from the DEP in violation of section 15.0.
Do I have anybody who wants to make that motion?
I'd like to just second that.
Somebody's gonna make it. I'm having a hard time with this because the beach I can see it being against the shore. I don't know what this is.
Well, so I suggest making the motion and seconding it. And just because you second the motion doesn't mean you have to vote in favor of it. Or
All right.
Can I move that?
Puts it up where we can call it for a vote.
Can I move that we do not uphold?
Sure, you can phrase it that way.
Because it doesn't sound like anybody actively wants to make that motion. I'd like to move that we do not uphold violation 6.
Yep. So I guess I would phrase it as a motion to conclude that the code enforcement officer erred in concluding that section 15.0 was violated because there was no beach constructed and therefore no permit was required.
Yeah, I'd just like to maybe specifically, and you can help wordsmith this, but I'd like to specifically say that the ordinances are too vague for there's really no ordinance that define the violation references an ordinance that doesn't even define the what a beach is, and that's really the not a code enforcement. The way you had phrased it was a little bit more ascribing an error to somebody. I think it's more of the ordinance isn't applicable.
Okay.
Or could not be applicable. I don't know.
Can I ask Alex for clarification on something? Is that possible at this point?
Yes, yeah, the board can certainly.
Yeah. So, Alex, for this particular one, when the notice of violation was originally delivered, it says see Exhibit C. And so I'm looking at Exhibit C. And that consists of 2 pages with a before and after, and then another before and after. Can you point out to me from the notice of violation where specifically in Exhibit C we're identifying the beach?
Yeah, hold on one sec. Let me just see, get that up. All right, so the beach area that you guys were talking about on slide 24 is the area shown on Exhibit C page. There's no page number, but it's the second page of Exhibit C on the NOV. The right-hand side to the right of the stairs.
Could you share your screen, Alex? Sorry to interrupt you.
Yeah, sure. Hold on one sec. So it is this page here. So we've got the original before photo. This is the beach area. Actually, it's a little bit lower than that. So I'm going to draw it right here. You see the pink that I just drew?
Yes.
On the screen? Yeah. So that's the before. And then, why can't I? There we go. Then after, you can see down here, and you can only really see in this photo, a small section of it right here.
Yeah, that's kind of what I saw.
So you've
My
got
initial review.
the before up here, and there is a section of it, looks like over here, but these rocks all in this general area here appear to all have been removed. You know, down to the,
Yep.
you know, the dirt, I guess you could say, which I consider that to be construction of that beach area to, you know, increase that usability of it, really.
Yeah, thank you for that clarification, because when I originally reviewed this, I was focused on those areas as well as the area in front of the set of steps there. And then this photo, this exhibit, slide 24, kind of threw me off a little bit. So given what was in the original notice of violation, I do believe that the beach has been constructed, given the photos.
Can you walk?
Mission.
I didn't quite follow as quickly. I'm sorry. It sounds like that was pretty convincing to you, but I'd like to. So the bottom of the stairs is where there's a currently a beach. Is that what on Exhibit D?
Nope, like Exhibit C.
You're still sharing your screen, Alex. Exhibit C.
Yeah, so this is Exhibit C here. You can see, you know, if you come down here, you can see all the rocks at the bottom of the stairs.
Actually, we're seeing your.
Get your email out.
Oh, okay. Hold on, shared the wrong one. That better?
Yes.
Okay, so the bottom of the stairs here, you can see this general area is all large boulders.
Yeah.
And if we then look at the after photo, and this really is a better photo if you look at that other slide, but you can see now at the bottom of the stairs, this general area over here, the large boulders are gone. So, and I know, you know, the thought is, a beach area would be, sand all the way to the water. But if you think about this, the goal here probably is to come down these steps, because the water may come up to the bottom of the riprap or higher. But now when you come down the steps, you can walk into the water and not have large boulders in this swimming area. Before, you'd walk down into the water and you'd have to navigate and swim over large boulders. So part of the year it is a sand beach. Part of the year it's probably shallow water. In my opinion, they've created a beach swimming area.
Yeah. I think sadly it's just going to come down to what's a beach and what's not a beach. And that's.
Yeah, and if I can just weigh in, the reality is that that's a mixed question of law and fact. So I think in some ways I may have perhaps overcomplicated by trying to split those out. So I think that the board can make a call as to whether or not it's a beach. And you can certainly give your reasons for or against, but at the end of the day, the question is it a beach?
So, yeah, I made my opinion known to me, given the original exhibits. I do believe that would be considered a beach. You can even see it a little bit on the other set of steps. The same photo, but just off to the left.
This is in C, David.
Yeah, Exhibit C, the second page of Exhibit C.
Yeah.
What Alex pointed out, as well as what's in front of the other set of steps.
Okay.
So, in my opinion, and again, I had seen this originally, got sidetracked by this slide 24, but I do believe the beach has been constructed, given the photo evidence.
Well, something was constructed. I agree with you. I don't think that's debatable.
So, so we can just be bold in this and make a motion to say that's correct, that a beach has been constructed. Is that what I can do here, Attorney Wagner?
Yeah, you can make a motion that there is to uphold the violation. Uphold the violation because the board concludes a beach has been constructed and no permit was obtained to construct a beach.
So I am gonna say so moved. Is there anybody willing to second that?
Second.
So any further discussion on that?
Yeah, any further discussion? Greg, Fred,
No,
okay, so roll call vote in favor of keeping this. Tom, yes, no?
Yes.
Greg, yes or no in favor of keeping this as a
No.
violation? Fred, in favor of keeping this as a violation?
yes,
No? David also says yes, so majority vote on this particular item in keeping it.
Okay. So the next issue here I have is that violations 7 and 8 should be vacated. So let's turn to let's look at 7 and 8 and identify the standards at play and the particular arguments being made here.
Sure. So number 7, section 15, land use standards, item Q, clearing or removal of vegetation activities other than timber harvesting. Subsection C, in order to protect water quality and wildlife habitat, existing vegetation under 3 feet in height and other ground cover, including leaf litter and forest duff layer, shall not be cut, covered, or removed except to provide for a footpath or other permitted uses as described in section 15Q, paragraphs 2 and 2A above. Figure out what section 15Q is.
This one seems much more clear in the photo evidence. So I'll just start off with that. I don't, we can discuss it obviously, but I think if what we're talking about Exhibit C,
Yes.
it's
So we have three items to work with. Vegetation less than 3 feet in height was cleared or removed within 100 feet of the natural high water line of Sebago. This was not done to establish a footpath or purposes allowed by Shoreland zoning ordinance 15Q2 2A. This was done without a permit. Sorry to interrupt, Greg. I just wanted to
no.
focus in on some of the things that we can be considering.
Sure. Yeah, I'm actually not sure what the right format for deliberation is. So I
don't either.
just trying to get people on Exhibit C because I think it'll be useful for everybody's that kind of as we think through this. That's what I found useful. So
that's what yeah, and that's what Alex refers to as well. Exhibit C. So for the appellant with respect to violations number 7 and 8, existing vegetation less than 3 feet in height was not removed. It was simply trimmed down, leaving all root systems intact and topped off with natural bulk bark mulch. So I don't know. I've always considered removal. If I cut down a tree and I leave the roots, that's still removal of a tree. So I'm not convinced that something that was trimmed down, leaving a root system, is not considered removal.
yeah,
I agree with that.
yeah.
So in terms of what we're looking at, vegetation less than 3 feet in height was cleared or removed within 100 feet of the natural high water line of Sebago Lake. Given the visual evidence, I would agree that it has been removed, and they can essentially say the same, the appellant, that it was, they're not saying it was removed, they're saying it was trimmed down, leaving all root systems intact. And I guess again, for me, David, removal is making it disappear regardless of whether the stumps or root system remain. And this says, in order to protect water. So let's see. It says shall not be cut, covered, or removed. So this, I mean, according to the ordinances, things were clearly cut. And they were covered, as stated in the appellant's information here. They're trimmed down, topped off with natural bulk mulch. Topped off, I'm assuming, means covered.
David, I think it also got covered by riprap and that
Yeah,
erosion cloth. So,
you're right. Yep.
I mean,
That too.
there was a wide swath there of vegetation that was removed. I'd like to just make a motion that we uphold the violation 7 and 8.
Second.
Well,
Can I add as the motion to uphold violations 7 and 8 for the findings presented on page 7 of the proposed findings of fact, which I think summarize what the board has discussed here, that vegetation less than 3 feet in height was cleared or removed within 100 feet. This was not done to establish a footpath or other purposes allowed by the Shoreland zoning ordinance, and this was done without a permit.
So moved, or Tom,
Right. I think the motion is to uphold 7 and 8 for the reasons provided in the factual findings on page 7. And I heard it first, so I need a second.
I'll second.
Okay. Any further discussion? I suggest that.
I do have one discussion because it seems two separate issues here with 7 and 8. One is the removal, and then the other is removal without a permit. I don't know if we should be combining these two or not.
No, sorry. As I interpreted the motion, it was we could certainly vote on them separately. I think that's prudent. So why don't we, could the gentleman who made the motion, could you withdraw it?
Did I make it? I don't sure if you counted Tom or me, but I'll withdraw it if I made it.
Okay, let's go with that. I think it's withdrawn. So how about a motion to uphold notice of violation number 7 for the reasons provided in for the proposed factual findings, not including the failure to get a permit.
So moved. That one was definitely me.
I'll go ahead and second.
Okay.
So Tom, yes to keep this included.
Uphold the violation.
Very good. Greg, yes or no to uphold?
Yes, uphold.
Fred, yes or no to uphold?
Yes.
David also says yes, so unanimous on that one.
Okay.
So,
So how about a motion to uphold violation 8 based on all of the findings presented on page 7 of the proposed statement of findings of fact and conclusions of law.
yeah, so moved.
Seconded.
Roll call vote. Well, actually, any further discussion, gentlemen? Guessing not. So roll call vote. Tom, uphold, yes or no?
Uphold.
Greg, uphold, yes or no?
Yes, uphold.
Fred, uphold, yes or no?
Yes.
David also votes to uphold, so unanimous on that.
Okay. So I believe the next issue recognizes the 7th issue in the proposed findings. Violation of 12 should be vacated because the determination that stabilization work could have been completed from a barge must be made by the planning board and cannot be made by the code enforcement officer. So let's turn to violation 12.
We also have violation 15, or violation 11 that we needed to review. Is that correct?
I
Which
don't
was
think it was.
considered same as number 5.
Was that in the appeal?
Number 11, yeah.
Okay.
Well, they're, at least according to tonight's presentation, they're saying that number 5 and number 11 were one and the same. We upheld number 5, and we have to make a decision, I believe, on number 11 as to whether or not that's should have been combined with number 5. Is that a correct interpretation of what was?
Yeah, I think that's right. Yeah. So I think we can address that issue down the line. I think, like I said, I think it makes sense to go in the order of the issues presented in the proposed.
Okay, very good. So,
That puts it at violation 12. So if we look at,
all right, very good.
I think the board should identify the applicable standard at issue here, discuss the arguments, and discuss what factual findings it wishes to make.
All right, so unpermitted shoreline stabilization, no barge, so shoreline zoning provisions, section 15, land use standards, section C, piers, docks, wharves, bridges, and other structures or uses extending over or below the normal high water line of a water body or within a wetland. Further, item 12, vegetation may be removed in excess of standards in section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that the permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. Item A, when necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access way must be restored. Item B, revegetation must occur in accordance with section 15T. Uh, From the appellants, it says with respect to violation number 13 was actually intended to be number 12. The CEO cites the property owner for not accessing the shoreline by barge in order to conduct stabilization activities. The CEO lacks authority to determine that any purported failure to access the shoreline by barge constitutes a violation of the shoreline zoning ordinance. Rather, pursuant to section 15C12 of the shoreline zoning ordinance, the planning board, not the CEO, is tasked with determining whether access by barge is necessary, but only after deciding that such means of access is feasible. Because the planning board has not yet reviewed any stabilization application from the property owner, the code enforcement officer's determination that it should have been conducted by a barge is premature and exceeds its authority. And it's also a note here is noteworthy that the contract between the property owner and BLMC specifically contemplates the use of a barge to complete the work. So findings that we can look at is shoreline stabilization project was completed from the land. Project could have been completed from a barge. The use of a barge was feasible. I think there's also a point here is, can Alex enforce this?
So why wouldn't, I'm not, can maybe to just rephrase it, why wouldn't Alex enforce this, or the code enforcement enforce this? Or is it because the planning board issues the permit and so you didn't get the permit, so now the code enforcement officer can't enforce it?
Appears to be the argument from the appellant, yeah. Because there was no permit issued, Alex can't enforce this. Because Alex isn't in a position of determining what access is feasible.
I see.
Apparently, based on the appellant, only the planning board is able to determine what is feasible. Which I go ahead.
Seems like if the code is you need a permit, is it just that the code enforcement officer could say that you did this without a permit, but not that you did it improperly?
I guess I have a question for our attorney advisor here. If we uphold this one, and eventually this is going to go to the planning board, and if they actually issue them a permit or whatever it's called after the fact, can they just not enforce a fine on this one, even though we upheld that it happened, and Alex is within his just duties to enforce things, because it's not a planning board role to enforce?
So I'm not sure I quite follow that, but I think it's venturing into some hypotheticals here. So the CEO has the authority to enforce the zoning ordinance. So if a failure to get a permit, certainly something that CEO can enforce. If we're in a situation where a planning board grants an after the fact permit, enforcement of that would be for the CEO.
Okay, so eventually this is going to go to the planning board, right? And if they choose to uphold this, but just not fine them because they're going to get an after the fact permit.
So the planning board's not going to be dealing with any fines or anything like that. That's entirely the discretion of the CEO with the select board's approval when to bring an enforcement action. So I guess I'm not following.
Yeah, and I'm not sure, Tom, if we can look at what the planning board is going to do. We have to look at this as from the notice of violation that was issued on December 16th.
That's what I guess my question. Yeah, my question is, Alex has a job as code enforcement. If he finds something that isn't right, he can write a violation. So in this case, you know, the words say, if feasible, use a barge, but no one was given the opportunity to even, you know, discuss that because no permit was ever applied for. So I don't see how we can't uphold Alex's violation.
Yeah, in the findings here, it says a shorefront stabilization project was completed from the land. I think we can all agree with that. And it says the project could have been completed from a barge. The use of a barge was feasible. And that comes from Alex's testimony tonight. So we have to, you're right, we have to work through that. So there was no permit from the planning board. And CEO is code enforcement officer, so there's enforcement there of the codes. So does that mean if then it subsequently falls back to Alex as to making that decision of feasible, since the planning board was not given that opportunity? Does that seem a reasonable approach? I mean, I know the ordinances don't specifically lay that out, but is it reasonable to assume that, given that the planning board couldn't, that the code enforcement officer is in a reasonable position to make that determination? Or maybe I'm just off base here. Any feedback, gentlemen?
Yeah, I'm thinking and reading, but I'm wondering if maybe we could get Alex to clarify what is the ordinance that we're dealing, or what's this particular ordinance that we're enforcing, or the code that we're enforcing? Because there seems to be that the town's position hinges pretty heavily on the code enforcement shall find any provision of these ordinances. What is the actual provision that is being violated in particular to violation 12?
Is that a question for me?
Yes.
Oh, okay. So the barge violation is Shoreline zoning provision section 15 C
12.
Yeah, in the way that I viewed this was kind of a classic if-then scenario where you have waivers, and usually in any type of review process through the planning board, you know, there's waivers that can be granted by the planning board. So if you can't meet a standard, the planning board can waive it. So in this particular situation, the way I viewed it was, you know, if you can do the project, you know, by barge, you should. If you can't, then the planning board is allowed to grant you that special ability to be able to do it from the land. But because they weren't granted that, I feel they're in violation.
I see. So what do you think, gentlemen? So we can agree, are we in agreement that a shorefront stabilization project was completed from the land? I think we're all in agreement to that. Project could have been completed from a barge and the use of a barge was feasible. At least that's what's in our findings. And I think also is, for me, is does Alex have authority to make that determination? I would almost say the project could have been completed from a barge as determined by the CEO. The use of a barge was feasible as determined by the CEO. So I guess, so in lieu that there was no permit from the planning board, that's, we had to determine, is Alex able to make that call? I mean, there's nothing defining it in the ordinances, at least not that we've been made aware of or that I have found. But I would say that given Alex's role as a code enforcement officer, that who does work with the planning board at times, would be in a position to make that call, given the planning board was not given the opportunity to do so. To me, that seems a logical extension of his authority, given that he is a code enforcement officer. But then again, that's, again, looking at, is that a logical extension of his authority?
Yeah, I think unlike and I know we're not going into the procedural aspects of it, but I think 11 applies here a little bit because there really isn't a specific ordinance that says, or maybe there is. Let me just go back. Yeah. Never mind that.
Well, it does say under our ordinances, code enforcement officer, shall be the duty of the code enforcement officer to enforce the provisions of these ordinance provisions. If the code enforcement officer shall find that any provision of these ordinance provisions is being violated, he or she shall notify in writing the person responsible of such violation.
That's 16H2, right?
Thank you very much. Yep.
Can we make a motion to uphold violation number 12 in accordance with what just was H2? The code enforcement officer did his duties in accordance with that?
I think the motion would be that the board would uphold violation 11, right?
Number 12.
Number 12.
Yep, number 12, yep.
Violation of 12. Right, so I guess I just take issue with citing the 16H2 because really the standard we're talking about here is 15C12.
Right. Yeah, I was just trying to see, I'm trying to see for myself, does Alex have authority to do this?
Right, and so I think the argument that you're citing 16H2, just to how I see it is that 16H2 provides the CEO authority to find that any provision of the ordinance is being violated. So the argument is that gives the CEO authority to say that section C12 states that one of the requirements for a permit here would be that vegetation may be removed in excess of the standards, and construction equipment must be accessed to shoreline by barge when feasible, as determined by the planning board. So I get that. So I think it is related to, do you see this as a whole violation of a failure to get a permit, or can this be its own independent violation? So I think you're right to make that threshold determination of can this stand as its own independent violation.
So I see these findings. The only thing like I said, I don't know if it makes sense to say, the findings say a shorefront stabilization project was completed from the land. I think we all agree that this is correct. The project could have been completed from a barge. The use of a barge was feasible. I wonder if those other two need to say the project could have been completed from a barge as determined by the CEO in lieu of the planning board being unable to permit this. Same thing, the use of a barge was feasible as determined by the CEO.
I just think it good. Sorry, David.
No, that's fine. I just
think it goes back to that whole idea that there's an omnibus way to hide behind not getting a permit and then not being held accountable for violation because, well, you didn't have a permit. Or sorry, you didn't talk to the planning board to get a permit. I think that's kind of where I'm going with this. And it's just like, you've deprived us the opportunity to evaluate this, just like the opportunity to evaluate hazard trees, just like the opportunity to evaluate a lot of these things. And that doesn't, you kind of abdicate you from your obligation to, use a barge or not use a barge. So it's kind of like, sorry, like maybe the planning board would have said, you can not use a barge, but so I don't know, that's just kind of my angle in my head, but I'd like to hear feedback on that.
Yep, no, I totally agree with that. So, I mean, I'm willing to take a motion on however somebody wants to phrase this. I guess accepting.
So how about a motion to uphold notice violation number 12 because shoreline stabilization project was completed from the land. It could have been completed from barge, and the use of the barge was feasible. Therefore, there's a violation of 15C12.
So moved.
I'll second. So roll call vote. Tom, yes to keep this as a violation.
Uphold the violation.
Uphold, thank you. Greg, yes or no to uphold the violation?
Yes.
Fred, yes or no to uphold the violation?
Yes.
David also votes yes to uphold, so unanimous on that one. All right. 13, unpermitted tree removal within 100 feet of Sebago Lake. Shoreline zoning provisions.
Was 13 raised on appeal?
Well, yeah, well, it's a good question. It's in the findings as the 8th finding. Let me look. No. Let's see. Yeah, I guess as I review the information submitted from in that application, I don't see number 13 listed at all.
Now, so what I have as the next issue is so again, I'm going off of the issues and arguments.
Yep.
Yep, and so I see that as violations 1 and 2 constitute procedural error to be vacated because in fact they are the same violation and are only listed twice in order for the town to be able to see duplicative fines. And so, I think we can, so 8, 9, 10, 8, 9, 10, and 11 all sort of raise a similar argument about these all relate to the failure to obtain a permit, so they're duplicative. And it's an error for the code enforcement officer to break them out into individual fines. So I think we can let's discuss that argument directly now.
Did anybody see the message that the attorney Raymond sent that about duplications? She sent a chat out a little while ago.
Yep, so the message is just wanted to raise a procedural issue. I heard Attorney Wagner say the board was going to go through the various violations and then consider a redundancy issue afterwards. I just want to make sure that you're planning to consider and address the redundancy issue. So yes, I think we're addressing that one now because I'm suggesting that the issues and arguments raised here in the proposed findings 8 through proposed issues here 8, 9, 10, and 11 all have to do with that duplication argument.
And that's why I brought it up, because I thought that's what you were doing.
So we could either try to discuss that issue holistically, or we could follow follow what we've been doing here and take the lead here from the CEO and start with violations 1 and 2. Should they be considered separate violations?
For me, yeah, but I mean, based on information presented by Alex and the town attorney, I agree. And even in my own analysis of this, I do believe they should be considered separate because yes, one action, something can be permitted and still be in violation. And then you can also be in violation for just not getting a permit. So I don't believe that these are duplicate. I do believe that they can be considered separate.
Yeah, and I think it's important to raise the other argument that was made that, you know, that this certainly this board, just to be clear, I agree, does not have authority to issue fines or to be, you know, really it's up to the court. So I think how you're phrasing it is correct. You know, are these separate violations? That's within your purview.
I'm Greg. Fred, any further comments on this?
Yeah, I kind of think that
I just agree. I think that you're correct in that analogy of what it's two different separate violations.
are we just we're discussing all of them being combined now, or just,
No, I think we decided to address the following issues, and so we're dealing now with violations 1 and 2. Was it an error to treat them separately? Another way of phrasing it is it right that there are 2 separate violations here?
yeah, I think that they're separate.
I vote keep them separate.
Okay.
So how about a motion to deny applicants' arguments that notice of violations 1 and 2 should be struck down as procedurally invalid because they are 2 separate violations?
So moved.
Seconded.
So any further discussion, gentlemen?
Can you just rephrase that again? You said be struck down as being 2 separate?
Right. So I guess
Because that almost sounds like you're saying that they aren't two separate, and they are 2 separate, correct?
right. So what I'm saying is that by let me just I'm sorry. It is 12:20, and so my
Yes, it is.
brain is malfunctioning here. Let's try this again.
Let me withdraw. I'll withdraw.
Okay. A motion to conclude that violations 1 and 2 do not constitute procedural error and therefore should not be vacated because the board concludes they are 2 separate violations.
So moved.
Seconded.
So roll call vote. Tom, keeping them separate, yes or no?
Keep them separate.
Greg, keep them separate, yes or no?
Yes.
Fred, keep them separate, yes or no?
Yes.
David also says yes, so we're unanimous on that one with regards to violations 1 and 2.
Okay. So the next issue is violations 7 and 8 constitute procedural error and should be vacated because they are in fact the same violation and are only listed twice in order for the town to seek duplicative fines. So I think we should turn to 7 and 8 So we discussed this a bit before, and this pertains to removing vegetation less than 3 feet in height, and then removing vegetation less than 3 feet in height without a permit. So I think much of the discussion the board already has applies here, but I don't want to put words in your mouth, but defer the chair to guide the discussion.
I look at this as the same argument we had for 1 and 2. Same thing.
Okay. So what about could I get a motion to conclude that violations 7 and 8 do not constitute procedural error and should therefore be upheld because the town concludes they are in fact 2 separate violations?
So moved. Do we have a second? Anybody?
I'll second.
Okay. Any further discussion?
So what, I
oh,
have
go
a
ahead.
quick question before
Of
we.
course.
Yeah. What's the scenario in which you could violate 8 without violating 7?
Can you say that again, Greg?
What's the scenario in which you could violate 8 without violating 7? Because it was a little bit more clear with me on 1 and 2. We've kind of been.
Well, I guess for number 8, you have to get the permit.
Yeah.
Right. So if you can be in violation of the permit. And then for number 7, you could, well. I mean, it's a violation. Well, I see what you're saying. I mean, it's a violation of 2 separate ordinance items. One is 15. Number 7 is section 15 QC. Number 8 is section 14, item 5. So I mean, I do see what you're saying. But as I see this as 2 separate ordinance items. And I would, if this needs to be cleaned up, then the planning board needs to review it and clean up that potential.
So is it that you could get a permit and then like inappropriately perform what it is I don't know.
Yeah, that's a good point. I'm trying to see what the.
I'm sure you could get a permit for partial vegetation removal to make the footpath or whatever else is needed. But in this case, they took it all.
Okay, so there's a scenario in which you could permit vegetation to remove vegetation for some sort of, but then that wouldn't be included in the permit. So then how could you violate? It's like.
I think in some ways, though, it gets away from the issue of here, what we're dealing with is vegetation was in fact cut. And
Yep.
That violation 7, and a permit was not obtained, and that's violation 8. So I think, the frame of reference of time we're dealing with is.
Okay. So it's like a modifier of 7.
Sure.
Yeah, and like I said, I'm looking at the ordinances. There are 2 separate ordinances here being 2 separate ordinance items here in violation.
Okay.
Yeah, so I'm just reviewing what was in the findings So. All right, so we have a motion. And a brief discussion. So Tom, in favor of keeping these separate, yes or no?
Keep them separate.
Greg, in favor of keeping them separate, yes or no?
No, I'm not seeing it, to be honest with you. I'm kind of.
Fred? Oh, no. Fred, in favor of keeping them separate, yes or no?
Yes.
David, also in favor of keeping them separate. So majority vote on that one.
The next issue, violations 11 and 12 constitute procedural error and should be vacated because in fact they are the same violation. So I think we should review 11 and 12 and identify the standards at issue and have the same discussion about whether these are properly listed as two separate violations or if they should have been merged.
So number 11 is unpermitted shoreland stabilization with no permits. Shoreline zoning provision, section 15, land use standards, item C, piers, docks, wharves, bridges, and other structures or uses extending over or below the normal high water line of a water body or within a wetland. Vegetation may be removed in excess of the standards of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided there is a permit obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. When necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access way must be restored. Revegetation must occur in accordance with section 15T. Number 11, unpermitted shore stabilization, no barge, and it refers again to the exact same ordinance item. So further items here, number 11 says stabilization of the shore. This is Alex's write-up, says the stabilization of the shore front was completed from the land without a permit from the planning board or code enforcement officer. So 11 is requiring a permit. Number 12 is no barge. It says the stabilization of the shorefront was completed from the land when it could have been completed from the barge, which the contractor Rob Durant owns. So again, it's sort of the same thing. So number 11 is keying in on vegetation may be removed in excess of the standards of 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Number 11 is specific to the use of a barge. Again, that's where it's talking about as feasible as determined by the planning board. So while they both refer to the same ordinance item, they are focusing on two separate items. For number 11, it's really section 15C 12, where provided a permit is obtained by the planning board. And then item 12, no barge, is then also 12, 15C 12, but then construction equipment must access the shoreline by barge when feasible as determined by the planning board. So I do see it as two separate items. Shoreline stabilization, provided that a permit is obtained, and then construction equipment must access the shoreline by barge when feasible as determined by the planning board. So it's, even though it's for a reference to the same sections, it's two separate items, at least in my opinion. Gentlemen.
Yeah, I think yeah, I think they're separate.
So I would yeah, however, I want to go ahead and move forward with a motion that we need to keep them separate. I don't know how to.
So have a motion to a motion that violations 11 and 12 do not constitute procedural error and should not be vacated because the board concludes they are properly listed as two separate violations.
So moved. Do we have a second?
Second.
Okay, any further discussion? So Tom, keep them separate, yes or no?
Separate.
Greg, keep them separate, yes or no?
Yes, separate.
Fred, keep them separate, yes or no?
Yes.
David also says yes to keeping them separate, so unanimous on that one.
The 11th issue, violations 14 and 15 constitute procedural error and should be vacated because they are the same violation. So again, recommend we turn to 14 and 15 and do this same analysis.
So 14, vegetation removal in excess of what is allowed by the point system. Shoreline zoning provisions, section 15, land use standards. Item Q, clearing and removal of vegetation for activities other than timber harvesting. Further, section 2B, selective cutting of trees within the buffer strip is allowed, provided that a well-established stand of trees and other natural vegetation is maintained. For purposes of this section, a well-distributed stand of trees adjacent to a great pond or a river or stream flowing to a great pond shall be defined as maintaining a rating score of 24 or more in each 25-foot by 50-foot rectangular 1250 square feet as determined by the following rating system. And then number 15 is removal of vegetation without a permit. Shoreline zoning provisions, section 14, table of land uses, number 5, clearing or removal of vegetation for activities other than timber harvesting. So again, I see these as two separate items.
Yeah, I agree.
So,
And the actual finding to support that they in fact cite to two separate standards.
yeah. Yep.
Okay, so how about a motion to a motion that violations 14 and 15 should be upheld because they do not constitute procedural error because the board concludes they are different separate violations.
So moved. Do we have a second?
Seconded.
Any further discussion? So Tom, keep them separate, yes or no?
Yes.
Greg, keep them separate, yes or no?
Yes.
Fred, keep them separate, yes or no?
Yes.
David also says yes, so unanimous on that one.
Okay, so unanimous on that. So I'm going to turn your attention to the January 18th notice of appeal that Attorney Rachel filed. Section 3, the last bullet point is a procedural argument here. It says section 16H of the Shoreland zoning ordinance requires that any notice of violation issued by the CEO indicate not only the nature of violation, but also an explanation of the action necessary to correct it. Here, little or no direction was provided with mitigation. This is the argument that it simply says they must be corrected in 30 days. So I guess the argument here is, was this lack of guidance a violation that renders the entire notice of violation void? So just to summarize, the town's position was that 16H2A states that if the CEO finds any provisions of these ordinance provisions being violated, shall notify the person, indicate the nature of the violations, and order the action necessary. And I'm paraphrasing here. Including discontinuance of the illegal use. The notice of violation states that all violations must be corrected within 30 days. The corrections must include, but not be limited to, the submission of a plan compliance with the requirements of 30A MRS 4452. The town argues this is sufficient. The notice of violation provides the same level of detail contemplated by the ordinance. Additionally, the February 22 supplemental notification provides a greater violation, and that the owner made the decision not to appeal that supplemental notice of violation. So the proposed factual finding here is that the notice of violation and supplemental notice of violation identified the action needed to correct the violations. And the proposed conclusion is that is sufficient, consistent with section 16H2A.
Well, so I'm reading what Alex has written here. Corrections must include, but not be limited to, the submission of a plan compliant with requirements of 30A MRS 44523 C-2. I believe that was what was referenced by the town attorney and Alex. Clearly, I don't know that I've heard anything from the appellant that would be insufficient, or I haven't heard an argument of how that particular item was insufficient in a correction. I'm just throwing those things out there, guys. Thoughts?
I mean, it doesn't seem like they want to correct, but the 30 days seems kind of irrelevant. Or the explanation rather inside that window. Like, I don't think more information of the ordinances that were cited would have mattered. I guess that's kind of the argument, that what was provided was sufficient. Is there something in the statute that dictates more context needs to be provided?
That's a good question. It just says ordering the action necessary to correct it, and the action was submission of a plan compliant with the requirements of 30A MRS. That was the action necessary to correct it. So
Wasn't that a verbal from Alex? Didn't Alex give them a verbal onto that when he met with them? That they had to, submit a plan of how to, repair all the issues?
This is Tom. My brief recollection from all of this is, October 14th, it was discovered by DEP, and it was the site walk, and Alex gave them a verbal stop work, towards the end of October, like a couple of weeks later, or whatever. Here we are 5 months later, and we still don't have a mitigation plan submitted. So 30 days is long gone.
Mr. Chair,
Yeah.
and I recognize that, my client's appeal is not before us, but I just would want to correct that statement, or at least point out on the record that I think that's inaccurate. There have been multiple plans submitted. Whether they've yet to be approved or agreed to by the town is a question of interest, but there certainly have been multiple plans that have been submitted. And politely, respectfully, just looking around, and I know that we wish to have some completion here, but I think the last board members' comments may be on point too, which is, recollections are becoming maybe difficult at this point, and I see a lot of people doing a lot of moving. I think just trying to stay engaged and not fall asleep. But I'll leave it at that.
Very good. And I do appreciate the comments, and I would agree that based on the information I have seen, mitigation plans have been submitted and reviewed. I'm not knowing the particulars of those, but it is my understanding that those things have been happening. So
how about a motion that the notice of violation sufficiently identified the action needed to correct the violations described in it in compliance with the requirements of 16H2A, and therefore applicant's argument is denied.
So moved. Do I have a second? Anybody? Second?
Seconded.
Any further discussion? So Tom, sort of move forward that CEO was correct. Yes or no?
Yes.
Greg, move forward, the CEO was correct in his actions. Yes or no?
Yes.
Fred, move forward, CEO is correct in what was provided. Yes or no?
Yes.
David also agrees. So unanimous on that one.
So at this point, we have votes on all the 12 issues. Your ordinance provides that after the board makes a final decision, the written decision has to be issued in 7 days. In light of the fact that it's 12:45, and I agree that there are people nodding off, here's what I suggest. I think what we have here is a tentative decision, and I think that I can write up a written decision based on this, and at the board's next meeting, it can review that decision, and it can issue a final vote and final decision on that, and then I can make any final tweaks within 7 days and issue that written decision. So that would mean that no final decision is made tonight. So
That certainly works for me. Procedurally, does that mean we just further table it again until the next meeting?
Yes, with the instructions for me to prepare a written decision.
Okay.
The other thing is, I don't know if you saw, there's another message out there from the attorney, Ration again, about just wanted to make sure that there will be consideration of the last argument discussed at length relating to the duplication, that by getting a planning board permit for stabilization under 1417(8) and 2, this would alleviate the need to get individual permits for grading, filling, vegetation removal, and tree removal, vegetation removal and tree removal. I don't know if anybody saw that or not, but.
Well, I mean, I see this, but I mean, this is sort of forward-looking, you know. The notice of violation was issued on 12/16 and there was no planning board permit at that time, therefore, at that time, at least in my opinion, the notice of violation was issued appropriately. I mean, yes, it's great that planning board permit will be after the fact obtained, but I don't think in terms of this 12/16/2021 notice of violation that personally has bearing, but.
I know it was addressed. I just want to make sure we at least talked about it, where it was, put into the message.
Sorry, Attorney Rachel, do you mind just speaking to the issue that you're raising?
Well, I thank you very much for the opportunity. I appreciate the person raising it for me. Yeah, that was one of the things that I addressed at length. And I'm not saying that I want to be clear. I'm not saying we had a planning board permit. I'm saying that the process is, if you get a shoreland stabilization permit from the planning board, then those other things all are subsumed in that. So that was the issue that I've been addressing and raising. And I just wanted to make sure that was addressed in the findings, because that was a big issue.
Attorney Wyckoff, do you have a reply on that?
I will. I'll be very brief. One, this is not an issue that was raised in the appeal. When you look at the application for appeal, it's not raised there at all. It's new. It's from whole cloth here today. And second, beyond that, what Attorney Rachel is really saying is that pretend that permit was awarded, and then none of this other stuff are violations. That's what she's asking the board to decide and to find, and that just didn't happen.
So I'm going to offer my opinion, and I'm inclined to agree. And I don't think this was strictly raised. I also think that by addressing the issues the way that the board has, I think it has addressed this. It's agreed that these the separate numbers we discussed should be treated as separate notices of separate violations. So I think that addresses the issue. I also think that since we're essentially going to table deliberations so they compare a written decision, if the board thinks otherwise, having a chance to review this review of the written decision, we can certainly see if we need to make an additional motion to address that issue. So again, my recommendation, I think at this point remains the same, that I take my direction here from the votes that have been taken to prepare a written decision, and we resume deliberations to finalize that written decision and take a final vote.
I would agree with that.
Okay.
So,
I don't believe I need a motion for that. I do suggest that we try to identify the next date if everybody's game for that.
yeah, well, the next regular meeting, Sandy can confirm, but I think it's April 26th. Is that right, Sandy?
That's correct, David. It is April 26th.
Yeah, the board certainly could, if it wanted to try and schedule a special meeting in advance, but it's also within its right to wait for the next regularly scheduled meeting.
Do we have anything upcoming, Sandy, for the 26th? Anything new?
Yes.
What? How many?
I knew you were going to ask me that, and honestly, I do not recall. It's a somebody's getting a. I honestly don't remember, David. It's on Egypt.
That's fine. No, that's fine. That's fine. So I guess then the question is, do we try to schedule another meeting in advance, in between what we have now and the 26th? Sort of work through another one of these. Greg, Tom, Fred? I mean, do you want to do that? Do you want to wait until the next meeting?
Well, we have to table a whole bunch of stuff, right?
Yeah, we
Continue a whole bunch of stuff.
we haven't officially done it, but it looks like we're gonna have 4 tabled items plus this one. So 5 altogether. The next ones may go a little bit quicker because they're smaller in size and we have some stuff to build off of what we've already talked about.
I'm okay with either. I mean, I'm open if you want to do a separate one, or I'm okay if we wait till the 26th.
What's the preference? Can we survey the appellant and I'm curious what the town and everybody's perspective is on this.
I think it's a good question. So Attorney
I'm happy
Wyckoff,
to-
Rich, and Attorney
I'm
Brown.
happy- I'm happy to weigh in. From the town's perspective, the town would like to see these resolved as soon as possible. And, if the board was open to setting a special date in order to accomplish that, then the town would support.
Attorney Braun, Attorney Rachel, any comment to that?
Yeah, sure. I'm happy to do whatever is in the board's desire. I'm just looking at my calendar and it's crazy booked. So if people want to, I reserved the 26th because I thought that might be the day that we would be doing this anyway. But it just depends on what the date is that's floated. And of course, I just want to accommodate whatever the board is looking to do.
And availability would be my only concern, but apologies, I don't really have access to the calendar right now to confirm or not. I would expect the 26th is far enough in advance that were you to put something on there, most likely we'd be available for it.
Sounds like the 26th can be still a good date. Greg, Tom, and Fred. Well, Fred, you weighed in. You said either or. Greg or Tom?
I'm fine with the 26th.
Yeah, it's fine with me.
Do we want to consider an earlier start time? Typically, our start time is 7. Do we want to consider an earlier start time to avoid, to give us more time to talk about stuff? Anybody?
I'm okay with it, whatever time you want to start, so.
This one, and granted, the rest should go quicker. A full day, and that might sound absurd, and it certainly isn't something everyone would prefer. But I think an 8-hour day sounds probably reasonable to get through the 4 that you have plus this one.
Right. Well, I'll throw that out there to me. I don't know that I can commit to an 8-hour day. It's, like I said, it's a volunteer position and I'm certainly willing to put in time as necessary, but I also have commitments during the days, which make really only evenings available to me, so. Greg, Dean, Fred. Sorry, Tom, Greg, Fred.
Yeah, I mean, I think 4 2-hour meetings are probably more doable for the board than 1 8-hour meeting, but we do have a lot to get through. So maybe it's 2 4-hour meetings between now and the 26th. Maybe we split the difference and we try to do something the week of the 10th and the 26th so that we're not completely log jammed. Can we do we have to do the calendaring now, or can we just say, let's offline work on our best and then publicly announce it ahead of time and whatnot, or how does this work?
I would just say, as a municipal attorney, I do night shift lots of, I have 2 and 3 meetings a week per night. Wish that weren't the case, but it is. And so I'm not trying to kick this can down the road. I just know that in the week that you mentioned, the week of the 10th, I've got 3 night meetings that week.
Which nights do you not have night meetings? Just
I advocate for keeping it on the 26th.
I think there was a consensus towards the 26th. I think the discussion was more, should we bump up the start time to say 5?
Yeah.
Okay, well,
How do people feel about that? 5 o'clock start time?
I can't do.
Okay,
Yeah, no objection to that.
what
Okay
time,
with that.
what time can you do, Greg? What's the earliest you can start?
5 o'clock.
Oh, sorry, Greg Dean. What's the earliest you can start?
Oh.
My apologies.
Yeah, I mean, it's gonna be closer to 7, so like 6:30.
Okay. Is six doable, Greg? Can you be on at 6, or is 6:30 a better buffer for you? Greg Dean.
Yeah, we can do 6.
Okay. Tom, can you do 6 on the 26th?
Sure.
Fred, sound like you're good to go.
Yeah, I'm okay.
Yeah, I can.
How about a motion to table discussion of this to April 26th, starting at 6 o'clock?
Yeah. So moved.
Second,
In favor of 6 o'clock, 26.
In
Tom,
favor.
or Greg in favor, yes or no?
yes,
Yes,
In favor, David's in favor as well, unanimous.
Okay, then how about a motion to table the remaining items to on the agenda to April 26th?
Yeah, so moved. Second,
second,
Tom in favor of tabling all remaining items. till the
In
23rd.
favor.
Greg in favor, yes or no?
yes.
Fred, yes or
Yeah.
no? In favor. David's in favor as well.
Well, I turn it over to you, Mr. Chair, for code officer communications and adjournment.
Yeah, so Alex, you got anything, or are you asleep?
I've got nothing.
All right, so I will say to everyone tonight, thank you for your patience with all of this. It's been quite the experience going on 1 o'clock here, so thank you for your time and patience tonight. I will make a motion to adjourn. Do I have a second?
Seconded.
All in favor? You can say it out loud.
yes. Aye.
Yes.
All right, everyone. Have a good night.